according to the rules. We're going to be calling one case out of order today, and that is the second case on our docket, which is 25081. It is in saltwater disposal. That'll be called second to last. So anyone who's here for that case, that's when we're going to call it. Okay. Let's get on the record in case number 25166. This is AEP operating. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Darren Savage with Aberdeen and Schill on behalf of Alpha Energy Partners 2 LLC.
Thank you.
And Caitlin Luck for Covenant Hercules LLC, Christian Capstone LLC, Crusader Royalties LLC, and Chief Capital O&G 2 LLC.
Good morning.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Permian Resources Operating.
Thank you. Okay, Mr. Savage,
Mr.
this is your case.
Jonathan, am I muted? Star 6 or something.
Did you say something? Do we have any other entries of appearance?
Mr. Examiner, Jonathan Samaniego, representing American Energy Resources.
Okay,
Well,
thank you.
representative of American Energy Resources. Thank you.
Yeah, yes, sir. Thank you. Mr. Savage, this is your case, right?
Yes, sir.
Okay.
In this case, 25166, this is a refiling of an application. It's an amended application, and it was amended for the purpose of acknowledging Paloma as the operator for Alpha Energy Partners 2 LLC. The application requests in paragraphs A through F pooling of uncommitted interest under the subject lands, the approval of the wells, and cost and risk costs as well. So the intent is to include Paloma as an operator, and then as I understand, this case pursuant to the hearing examiner's order has been substituted for the March 4th contested hearing.
That's correct.
So I guess this was a status conference that was called because we moved this case to March 4th, and that left an opening for the status conference.
This case was noticed today because it's a new case, even though it's an amended case. So we needed to satisfy the notice requirements. But the old case, which was case number 24944, which was dismissed by yourself after you filed the new case, was the subject of the pre-hearing order that was issued November 21st. Your original case was filed on October 8th. So March is quite a ways away from March 8, from October 8, which is why we amended our pre-hearing order to make sure everyone knew that we were having the contested hearing March 4.
Yes, sir.
All right. There are two cases on the March 4 docket. I believe this is the older case, and it will go first. Was there anything else, Mr. Savage?
I don't have anything else.
Okay. Ms. Luck?
And Mr. Hearing Examiner, my clients object to the case proceeding to the contested hearing on March 4th due to the timing of this application.
Timing of which application? The first one or the amended one?
The amended application. So
Right.
My clients collectively are all interest owners in this unit. However, they did not receive a well proposal letter timely before the filing of the application, and the division precedent here requires well proposal letters to be provided or some other type of voluntary agreement to the parties to be pooled in the unit. So because my clients weren't provided a well proposal letter, I think it was sent on February 3rd. So we're looking at 10 days before now. That's not timely in advance of the filing of either the amended application or the original application in October. And there are some title disputes related to some of my clients' interests, but it's not all of them. So they should have each received well proposal letters in advance of the application filings. And so my clients are prepared to file a motion regarding this issue before the divisions for consideration before the March 4th hearing if possible.
So Ms. Luck, let me try to understand what you're saying here. Were your clients provided the proposal before October the 8th?
No.
Okay. So Mr. Savage?
Yes, sir. Alpha sent the well proposal on August 21st, 2024. They sent it to what they viewed as the predecessor owner
Mhm.
to the interest. So that would have been timely. Then, as a courtesy, the Alpha sent a follow-up well proposal to Chief and Covenant and that was sent out February 3rd, and it explained that the previous well proposal had been sent, and they viewed it as still being active regarding the date that it was sent, and that this provide the follow-up letter provided the additional information for the well proposal, and then we also provided notice for the hearing for March 4th. I would like to point out that I believe that Ms. Luck appeared at the hearing for case 24944 with their clients, and so they were aware of the proceedings.
Ms. Luck?
That is correct that my clients were aware of the proceedings, but the burden here is on the applicant to send the well proposal letters to the interest owners that it knows of at the time the application is filed, which did include Chief and Covenant. And so as of the earlier hearings following the original application filing, my clients were at that time ready to present these objections to the application proceeding regarding not getting notice and not getting the well proposal letters. And so it is appropriate for the division to consider the fact that my clients were not properly proposed voluntary agreement prior to the proceeding going to pooling. And so that's why we would like for either the March 4th setting to be pushed out at least 30 days to allow for consideration of a voluntary agreement here by my clients, or the case to be dismissed entirely and refiled after my clients have had appropriate time to consider the well proposal letters.
According to Mr. Savage, the predecessor in interest was noticed back in August of 24. So, Mr. Savage, you said the predecessor in interest. When was the interest exchanged? When did that?
I don't have that information, but I do have the landman online. If you want to clarify some of the details on this,
All right.
John Kaufman, he would be glad to
Okay.
address any questions.
So, Ms. Luck, when did your clients take over this interest?
They obtained their interest in October of 2024, so around the time that the original application was filed in 24944. But it's my understanding at that point in time, Alpha, the applicant, was aware of Chief and Covenant's interests both. And so well proposal letters should have been sent to my clients as the current interest owners at the time the applications were filed.
So your clients purchased the interest. How did your clients get the interest from? Who's the predecessor, Mr. Savage?
I believe it's Nickel River.
Nickel River. So, Ms. Luck, is that correct?
That's correct.
Okay. How did your clients, Chief Capital, Covenant Hercules, Christian Capstone, and Crusader Royalties, those are your clients?
Yes, sir.
Okay. How did they obtain their interest from the predecessor?
I don't have the specific assignments with me here today, but I'd be happy to provide those to the division along with a filing regarding notice. But it's my understanding that their interests were filed of record as of October of 2024 when this application was filed, and the applicant was aware of their interest in the unit.
Ms. Luck, the application was filed October the 8th.
I understand that.
So then notice would have been sent out previously.
Right, but the rule reads that it's either an interest of record or known to the applicant at the time of the filing. And so it's my understanding that Alpha knew that Chief and Covenant's interests were out there, owned by Chief, not Nickel River, at the time the application was filed, and notice should have been sent to both Chief and Covenant at the time the application was filed.
Okay, I understand your point. I'm just not finding it persuasive. So I'm not going to change. I'm denying your motion to reset the hearing. The hearing will occur on March the 4th. You're welcome to participate. Are you going to present witnesses?
Yes, I believe that we would go ahead and present land witnesses that talk about the lack of a voluntary agreement and efforts to reach voluntary agreement with my clients prior to proceeding to pooling. That's a requisite factor that an operator has to show. And so my clients would be prepared to discuss that factor in terms of the pooling.
So are you going to file a pre-hearing statement?
Yes, Mr. Hearing
Okay.
Examiner.
All right, perfect. Ms. Vance,
I have nothing to add. Thank
are you
you.
monitoring?
Just monitoring.
Not objecting?
No.
Are you going to participate in the hearing?
I will listen in.
Okay, thank you. Mr. Samaniego, this is your opportunity. Do you have anything to say about the March 4 hearing?
Yes. Darren Savage and his clients have made statements at the previous hearing. I believe it was when it was the Alpha hearing, and they had made statements on record that American possibly owns a well, and that they said that it was a well bore. So just going off of those statements right there, Alpha has not sent American Energy Resources notification. They have not sent American Resources notification of these changes that Paloma is farming out the lease. So the fact that there has been no notifications whatsoever sent by Alpha to notify American, again, I'm requesting that this case be dismissed or for it to also be pushed off for another 60 days because American right now is finishing up title work. We are finishing up our application, and we will be filing our application to drill, if not by the end of this week, early next week.
Mr. Savage?
So Mr. Samniego's company owns a wellbore only interest. And I'm looking at the assignment right here in front of me, and it says it shall not be interpreted as conveying any oil, gas, or any other mineral rights. It's a wellbore only, therefore they are not entitled to notice.
Okay, thank you, Mr. Savage. Mr. Samaniego, I welcome your participation at the hearing on March 4, but I won't be delaying the hearing. You can file whatever you like if you want to present. Mr. Samaniego. Okay, do you know how to mute? Do you know how to mute, Mr. Samaniego? Okay, thank you. Mr. Samaniego, if I'm speaking, you don't speak. I mean, this is like 101 hearing lesson. So I hope you're not going to be like this at the hearing because we'll be muting you if you try to talk over anyone else. You have your opportunity to speak, and I'll make sure you have it. So if you have a case and you plan on presenting witnesses or evidence, please follow the rules in 19.15.4. Otherwise, is there anything else from you, Mr. Savage?
No, thank you, sir.
All right. So we're off the record in this case, and we're going to move on to our next case, 25081, which we're going to call second to last.
You said I would have a statement. You didn't give me my statement. You said I would have my time. You didn't give it to me.
You had your time, and you've been muted now. We're now moving on to item number 3. This is 24185. It is also joined with 24886. Entries of appearance, please.
Yes, good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant EGL and PBEX.
Thank you. Are there any, I know there's other parties.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating.
And Ms.
LLC.
Bennett, you withdrew your objection. Is that correct?
We did, yes.
Okay, very good.
And good morning, Mr. Examiner. Dana Hardy on behalf of COG Operating and Concho Oil and Gas.
Morning.
Good morning,
And you
Darren
withdrew-
Savage with Avenue and
withdrew
Shield.
your objection as well, right?
That's correct. We do not object.
But wait, you did not object?
COG does not object.
Does not object. Okay.
Correct.
Good morning, Darren Savage with Avenue and Shield on behalf of Cimarex Energy Company, and we're just monitoring, preserving
sir.
rights.
And Mr. Hearing Examiner, I am also entering an appearance on behalf of Matador.
Okay. I have that Avant had objected and withdrew. I also have Snow. Who's representing Snow?
I am
Oh.
Dina Bennett on
and
behalf
you
of
withdrew their
Snow.
objection. as
Yes, yes.
well. Okay. And MRC Permian also had an objection.
Previously, I think in the north half, but that was withdrawn.
Right. And who's representing MRC Permian?
That's myself.
So you were representing EGL and a party that was objecting to your application?
That's correct, but I've confirmed no conflict at this time.
Okay. Why don't you proceed?
Thank you, Mr. Hearing Examiner. And before I get started, one of our witnesses has not appeared before the division. So just wanted to let you know, and we have included a copy of her resume, and she's available for questioning.
Let's get her. Are you going to present both cases together, by the way?
I will.
Okay. What is the name of your witness?
Her name is Ruth Hazel.
Can we put her on the screen? There, I see you. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Would you state and spell your name for the record?
My name is Ruth Pelzel, Ruthpelzel.
And what field of expertise are you seeking to be qualified before this division?
New Mexico.
No, that's not what I meant. Which field of
Okay.
expertise are you seeking to be qualified as an expert?
As a
Landman.
landman, sorry.
Very good,
Sorry.
I understand. What education do you have that goes toward your expertise?
I have been working as a landman in New Mexico for the last 5 years. As far as education goes, I have a bachelor's of arts from BYU, and I have a law degree from Texas Tech.
Okay, so you're a lawyer.
Yes, sir.
And your expertise, can you just tell me who you've worked for and what your duties have included?
Yes, sir. Recently, I worked at ConocoPhillips and worked operations in the Northern Lee area. I helped put together units, put together projects, work with other companies to try to get to an agreement so that we could drill wells. Prior to that, I worked more as a land specialist where I worked on title curative issues. And that's really most of my experience throughout the years is title and then operations.
And who employs you now?
I work for PBX.
PBX, okay. PHS?
PBX.
PEX, thank you.
B as in boy.
PBX,
PBX. That's correct.
thank you. Is that related to EGL?
Yes. So I believe Ms. Pelzel could explain it better, but it's my understanding that PBEX acquired EGL.
Okay, what is your position with PBX?
I'm currently working as a landman here.
Okay, and how long have you been there?
About 2.5 months.
Okay, very good. Okay, so from here on in, you're qualified as an expert in landman, as a petroleum landman before this division. Ms. Vance?
Thank you, Mr. Hearing Examiner. So I'll go through both of these cases really quick. The case number 24886 is the North Half case, and that involves the northeast quarter of Section 32, and then the north half of Sections 33 and 34, and that's Township 18 South, Range 32 East, and that's in Lee County, New Mexico. And I'll note that there is a overlap in this case. We provided notice, and we did not receive any feedback or protest regarding that. And in this case, the wells the wells involved, the initial wells are the Bond 32 TAC 34 FedCom 101H, 102H, 103H, and 201H, 203H, and 205H. And with that, the 102H and 203H are the proximity wells. And I will note, I did get some feedback from Mr. McClure that there were additional pools involved, and we did update our compulsory pooling checklist, as well as the C102s, and we got that filed yesterday. So that should be, I believe, up and available to the examiner for review while we're going over the cases. And then in case number 24185, that's the South Half case, and that involves the South half of Sections 33 and 34 And again, the same township and range, township 18 South, range 32 East. And the wells, the initial wells are the Bond 33, TAC 34, FedCom 104H, 105H, 106H, 207H, 209H, 211H, and then the 105 and the 209 are the proximity wells. And we have included a copy of the applications, the compulsory pooling checklists, as well as the self-affirmed statements of landman Ruth Pelzel, who is now credentialed as an expert. And
Can I
then,
interrupt you for a moment? I'm looking at the filing from yesterday.
sure,
Is it an amended exhibit packet?
it is, and there was a little bit of confusion on my part because it's a new process where we're having the technical examiner asking
Yes.
for corrections beforehand.
Yes.
And I was under the impression, because of a couple of earlier instances where I was able to send it directly to Freya and swap it out before the hearing. And so that's what I was doing. And I apologized to her this morning because I think I overloaded her yesterday with a bunch of swap outs. But in the future, I will make sure we'll just go ahead and file with the cover an amended package. So, but what is there
Right.
should be the
I see it.
correct one.
So include a cover letter so that we know what you updated. So Mr. McClure also knows that what you've done.
Absolutely. And
I
I did,
understand.
and I did email him a copy yesterday, so he should have that.
Okay.
And then we also have this self-affirmed statement of geologist Matt Party, who's also on the line and available for questions. We've included the requisite exhibits for land and then geology. I will note we did provide an overlap exhibit for case number 24886. And then lastly, we have Exhibit E, which is my self-affirmed statement of notice with a sample letter. We've got different timeframes on that because we took over one of the cases from Mr. Bruce. But in case number 24886, the letter was timely mailed on October 11th, 2024. And then in case 24185, the letter was timely and mailed out January 24th, 2025. And then similarly with our notice of publication, the affidavit of notice of publication for case number 24886 is October 16th, 2024. And then in case number 24185, the affidavit of notice of publication is dated January 30th, 2025. And unless there are any questions, I would ask that the cases be taken under advisement at this time.
Are there any objections to the exhibits? Not hearing any. Your exhibits are admitted into evidence. Mr. McClure, do you have any questions on these two cases?
No questions for either of these cases, Mr. Hearing Examiner.
Thank you, Ms. Vance. These two cases are taken under advisement.
Excellent. Thank you.
Let's move on now to 24886 and 24185. These are items 4 and 5 on our agenda. Entries of appearance, please.
Mr. Examiner, I think, did you mean to call 24832 and 24831?
Maybe I did. I don't know.
I think so.
I think you're right. Each yellow's done. Okay. So let's go to number 5 and 6 on our agenda, 24831 and 32.
Thank you, Mr. Examiner. Dana Hardy, on behalf of COG Operating LLC.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating. And I'm also entering an appearance on behalf of Coterra Energy. Coterra acquired Avant Operating on January 17th, 2025. And so I am appearing on behalf of both Coterra and Avant in these cases.
Thank you. And you had an objection that you withdrew on behalf of Avant.
That's correct.
That, of course, works with Coterra.
Yes.
Okay. Thank you.
We're preserving the right, though, to seek de novo review if we need to.
Of course. Ms. Hardy.
Thank you, Mr. Examiner. In these cases, COG seeks to pull interest in the Bone Spring and Wolf Camp formations underlying a 1,920 acre non-standard spacing unit comprised of sections 22, 27, and 34, Township 20 South, Range 33 East. The units will be dedicated to the Donkey Pot Roast FedCom wells. Case number 24831 involves the Bone Spring, and case number 24832 involves the Wolf Camp. In each case, we provided the affidavits of landman Michael Monju and geologist William Schellenbach. Mr. Monju has previously testified and been recognized by the division as an expert in petroleum land matters. Mr. Schellenbach's affidavit states that he has not previously testified before the division. I believe he determined after submission of the affidavit that he actually has previously testified and been recognized as an expert, but he did provide his CV and is available for questions if the division has any.
I'll rely on your word.
Thank you. And Mr. Manju provides the standard land exhibits as shown in Exhibit A3. COG is only pulling 3 working interest owners, and the rest of the pooled parties are record title and overriding royalty interest. Mr. Schellenbach provides the standard geology exhibits. Exhibit C includes my notice affidavit and the associated attachments. Notice was timely sent by certified mail in September and was also timely published in September. Because these are non-standard spacing units, we did provide notice to the operators in these surrounding tracts. With that, unless there are questions, I request that the exhibits be admitted and that these cases be taken under advisement.
Are there any objections?
No objections.
Thank you. Your exhibits are admitted into evidence. Mr. McClure, any questions on these 2 cases?
Mr. Hearing Examiner, I have no questions for either of these cases.
Thank you. They're taking under advisement.
Thank you.
Thank you, Ms. Hardy. Okay, moving on now to 24888. Entries of appearance, please.
Dana Hardy on behalf of COG Operating LLC.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating, and I'm also entering an appearance on behalf of Coterra. Coterra acquired Avant on January 17th, 2025.
And you withdrew your objection?
Yes.
Very good. Ms. Hardy.
Thank you. In this case, COG seeks to pool interest in the Bone Spring underlying a 1,280 acre non-standard spacing unit comprised of sections 26 and 35, Township 20 South, Range 33 East in Lee County, and proposes to dedicate the unit to the Ore Digger Federal Wells. In this case, as in the prior cases, we provided the affidavits of landman Michael Monju and geologist William Schellenbach, both of whom have been recognized in their fields before the division. Mr. Monju provides the standard land exhibits. The plat of tracts and ownership information is included in Exhibit A3, and Exhibit A4 shows the ownership in the tracts surrounding the non-standard spacing unit. Mr. Schellenbach provides the standard geology exhibits. Exhibit C includes my notice affidavit and the associated attachments. Notice was timely sent by certified mail and was also timely published in October. And again, because this is a non-standard spacing unit, we provided it notice to the operators in the surrounding tracts. With that, unless there are questions, I request that the exhibits be admitted and that this case be taken under advisement.
Are there any objections?
No objections.
Your exhibits are admitted into evidence, Mr. McClure.
No questions, Mr. Hearing Examiner.
Thank you. We're taking this case under advisement.
Thank you.
Now calling number 8 through, well, the next several. This is 24932, 34, 35, 36, 37, and 38 for Permian Resource Operating.
Yes, Jackie McLean on behalf of Permian Resources.
Good morning.
Good morning.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating LLC, and I'm also entering my appearance on behalf of Coterra Energy. Coterra Energy acquired Avant's interest on January 17th, 2025.
Why do you feel the need to say that each time?
So that it's in the record for each case.
I see. Okay. And then do we have COG with us?
Yes, Mr. Examiner. Carrie Hatley on behalf of COG Operating and ConocoPhillips.
And you withdrew your application, Ms. Hatley?
We withdrew our objection, but we
That's
would like to maintain our entry of
That's
appearance.
what I meant. Thank you.
Thank you,
And,
sir.
And good
And Ms.
morning.
Bennett, you did the same?
Yes.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of XTO Holdings LLC. And we're just entering an appearance.
Okay, so this is your entry of appearance now.
We filed yesterday, and it looks like it's up in the case files, but it's not on the worksheet.
Thank you, Ms. Spence.
Good morning, Darren Savage on behalf of Cimarex Energy Company. I'm sorry, excuse me. Withdraw that. Darren Savage on behalf of Cross Timbers Energy. Thank you.
And you're just monitoring?
And monitoring, yes, thank you.
Ms. McLean?
Thank you. It's a full house.
Yes, it is.
Thank you. In case numbers 24932 and 24934 through 24938, is that? Yeah. Permian Resources seeks an order pulling uncommitted interests in the Bone Spring and Wolfcamp formations in the west half of sections 11 and 14, Township 20 South, Range 33 East. And Permian Resources will dedicate these spacing units to the Anaconda wells. Permian Resources submitted amended exhibit packets yesterday at the request of Mr. McClure. And those include the land testimony and exhibits of Mark Haddock, who has previously testified before the division, and geology testimony and exhibits of Cole Hendrickson, who has also previously testified before the division. The notice exhibit also includes a copy of the notice letter sent to working interest owners and overriding royalty interest owners on October 17th and 18th, 2024, and a copy of the affidavit of publication for October 24th. With that, I ask that exhibits A through C be admitted into the record in these cases and that they be taken under advisement.
Are there any objections? Not hearing any, your exhibits are admitted into evidence. Ms. McLean, did you amend your summary of context on Exhibit 8A? A5?
We did, yes.
That's better. That microphone.
Yeah, I'm like,
better, isn't
which
it?
one can I use? Yes, we did. And I believe that that is reflected on the notice that we filed yesterday. It shows that we amended Exhibit A5
Okay.
and Exhibit A6. And then for case numbers 24937 and 24938, we also amended the compulsory polling checklist.
I see. Thank you. Mr. McClure, any questions?
Mr. Hearing Examiner, I just finished reviewing their amended exhibits, and I do not have any questions for any of these
Okay.
6 cases, I think.
Then, Ms. McLean, thank you. Your 6 cases are taken under advisement.
Thank you.
And we're going to now move to, let's see, 38. Now calling item 14 on our agenda. This is case number 24991 XTO Energy.
Good morning, Mr. Examiner. Miguel Suazo with the Santa Fe office of Beatty and Wozniak, appearing today on behalf of XTO Permian Operating.
Good morning.
Good morning.
Are there any other parties that you know of that entered on this case?
There are not.
Mr. Suazo, I can't find your pre-hearing statement.
Let me look. Yeah, I'm not seeing it online either. I thought we submitted it. How would you like to proceed? I'm not seeing it on the website.
As far as I know, the rule requires a pre-hearing statement, or else you're not, unless you're, I mean, otherwise I believe you're prevented from presenting any witnesses or evidence.
My office has confirmed that we did submit it. I don't know why it's not on the website.
Okay. So you submitted, so you have a record of it being submitted?
Yes, according to my office, we do have that record.
Okay.
We can submit it again now if that helps.
Freya?
There's nothing in the queue. I can go in and check the back end of the case and see if something was submitted and maybe inadvertently rejected.
Okay, would you do that?
Yeah.
So, Mr. Suazo, while she's doing that, Rule 19-15-413B requires a pre-hearing statement before you can present any evidence. That would preclude our proceeding today. I do know that there are other issues with this case.
Okay.
So I think what I'll do is I And I think it may require dismissing this case and refiling it, because I think there's problems with the legal description in the notice of this case. So let me ask Mr. McClure to go over this with you while Ms. Chance is looking through the back end of the queue. Mr. McClure?
Thank you, Mr. Hearing Examiner. Let me actually get the exhibit open here. Yeah, Mr. Zazo, if I can direct your attention to, well, I guess the application might actually be the easiest. What page on the exhibit packet is it?
4 of 41, I believe.
Yeah, and yeah, I was gonna say the first page looks like it's page 3 of 41. If I can direct your attention to that very first paragraph where there's a legal description of the lands being asked for the NSP.
Okay.
On there, it references the north half of the south half of section 23. Do you see where I'm referring to?
I do.
That should actually read, based upon the maps at least, that should read the north half of the north half of section 23. And it appears that this error, typo, whatever it is propagated throughout the rest of the application and all notice material.
Okay.
And as such, a new notice is going to be required, and likely a new case actually be created for it. But I'll leave that in Mr. Hearing Examiner's discretion there.
Thank you, Mr. McClure. Mr. Suazo, how do you want to proceed?
Well, it doesn't sound like the option is to proceed today, obviously. So I guess if we can continue to the next, the soonest opportunity to present a hearing by affidavit, we can submit the corrections and go forward that way.
I think I'm just to think through this with you, Mr. Suazo. I think if the issue was just a pre-hearing statement, you would file it and we could take it up at the next opportunity. But I think with the notice issues, don't you have to dismiss and refile an amended application?
Yeah, I think that's probably right.
I mean, we can try to help you expedite this. I know your client must want something from us in a timely fashion. So we can try to fast track it for you and get it to we can add it to a special docket for a hearing by affidavit, if that helps you.
Sure.
But let's first get it, refiled and get the notice out there per the rules, get a pre-hearing statement in here. And then you can file something with the hearing division and ask for some special consideration to get it on an earlier docket, and I'll work with you.
Okay, thank you. I appreciate that.
All right, so will you file a motion to dismiss this case by, let's say, tomorrow?
Of course.
Okay, and then we'll get an order out there dismissing the case, obviously without prejudice, and look for your amended application. Thank you, Mr. McClure. Thank you, Mr. Suazo. We're off the record in 24991.
Mr. Examiner, I did see that the pre-hearing statement was uploaded as a draft, but never formally submitted.
I see. Mr. Suazo?
I don't know. I mean, I would have to check with our folks that submit the document, but I know that we submitted it.
Freya, what does that mean? It was uploaded as a draft? I don't know. I don't understand the process myself.
I don't know the full steps either, but I just know that it never entered the queue for me to review it because it wasn't, they didn't press the submit button. It's the first steps were started, but not completed.
Okay. So, Mrs. Suazo, it sounds like whoever uploaded it didn't complete the process by hitting the submit button.
Okay, I'll have to check with our administrative team.
I mean, they know how to do it because we have other documents filed by your administrative team. So I don't think, I guess it's just an error. But anyway, the case will be dismissed and refiled. So we'll work with you.
Okay, thank you.
We're moving on to number 15 on our docket. It is actually 3 cases from Permian Resources LLC, 24997, 98, and 99.
Jackie McLean on behalf of Permian Resources.
Good morning.
Good morning.
Are you the only party, Ms. McLean?
Yes, there's no entries of appearance in this one.
Okay, please proceed.
Thank you. In case numbers 24997, 998, and 999, Permian Resources seeks an order pulling all uncommitted interest in the Bone Spring Formation underlying 320-acre, more or less standard horizontal spacing units comprised of the north half, south half, and south half of Section 6, Township 19 South, Range 28 East, and the north half, south half, and south half of Section 1, Township 19 South, Range 27 East in Eddy County. And these units will be dedicated to the Terlingua wells. Permian Resources submitted exhibit packets, which include the land testimony and the exhibits of Travis Maka, who has been previously admitted as an expert in land, and you know what I mean. And the geology testimony and exhibits of Chris Canton, who has also previously testified before the division. And then I also wanted to note that COG and Marathon have signed a JOA. Or sorry, that's for that's not for this one. That's the next case. So that it just stands as is. It stands. And the notice exhibit also includes a copy of the notice letter sent on December 6th and a copy of the affidavit of publication for December 12th, 2024. And with that, I ask that exhibits A through C be admitted into the record in case numbers 24997, 24998, and 24999, and that the cases be taken under advisement.
Are there any objections? Not hearing any. Your exhibits are admitted into evidence. Mr. McClure?
No questions for any of these 3 cases, Mr. Hearing Examiner.
Thank you, Mr. McClure. Moving on to number 18 and 19 on our docket. That is 25000 and 25001, Permian Resources.
Yes, Jackie McLean on behalf of Permian Resources.
Thank you.
Good morning, Mr. Examiner. Carrie Hatley on behalf of COG Operating and Concho Oil and Gas.
Good morning. Any objections?
No, sir.
Thank you. Ms. McLean?
Yes, thank you. And I just wanted to note, I put this in 2 places. It should be for here. Like it does that COG and Marathon signed a JOA this morning. So they're no longer going to be pooled in these cases, and case numbers 25000 and 25001. So following the hearing, we'll be submitting an amended exhibit packet to remove them from the exhibit A3.
Thank you.
And in case numbers 25000 and 25001, Permian Resources seeking an order pulling all uncommitted interest in the Bone Spring Formation underlying sections 4 and 5, Township 19 South, Range 28 East in Eddy County. And these units will be dedicated to the Lajitas wells. And these are proximity tract units. Permian Resources submitted exhibit packets last week, which include the land testimony and exhibits of Travis Maka and the geology testimony and exhibits of Chris Canton, both of whom have previously testified before the division. The notice exhibit includes a copy of the notice letter sent on December 6, 2024, and a copy of the affidavit of publication for December 12th, 2024. So I ask that exhibits A through C be admitted into the record in these cases and that the cases be taken under advisement.
Any objections? Your exhibits are admitted into evidence. Mr. McClure, any questions?
Mr. Hearing Examiner, I don't have any questions other than to confirm with Ms. McLean. Which cases did you say you were submitting a new pulled person list for?
In both cases, 25000 and 25001.
Okay, sounds good. That was my only question. Thank you, Mr. Hearing Examiner.
And Ms. McLean, that's going to reflect the JOA with, did you say COG?
Yes, in Marathon.
And Marathon, thank you. Okay. All right, we're off the record in those cases. They'll be taken under advisement. We are now going to call a series of cases Beginning on line 20, these are case numbers 25011, 13, 14, 15, 18, and 19, Permian Resources LLC.
Yes, Jackie McLean on behalf of Permian Resources. And there should be no entries of appearance.
Please proceed.
Thank you. In these cases, Permian Resources seeks an order pulling all uncommitted interests in the Wolfcamp Formation, underlying a standard horizontal spacing unit comprised of all of sections 15 and 16, Township 20 South, Range 28 East, and in the Bone Spring Formation in the south half of sections 15 and 16. And this is in Eddy County. And these units will be dedicated to the Foster's wells.
Ms. McLean, did you get the email regarding the gas pool?
Yes, and we submitted, we submitted an amended exhibit packet in all of these cases, well, in case numbers, let me pull this up. 25014, 15, 13. I believe that's it for the Wolfcamp wells. 3, 4, 5. Yes. At the direction of Mr. McClure. Those were submitted yesterday.
So which cases have the amended, I couldn't hear you. Which cases have
sorry.
the amended exhibit
The
packets?
amended exhibit packets are. Sorry, I'm just.
The notes I have here look like it affects cases 11 through.
It should be 25011,
Mhm.
25013,
Mhm.
25014, and 25015.
That's what I show.
Okay, because there's a gap in numbers.
Got it.
Yeah, so we filed those to correct the building blocks and the non-standard unit spacing information on the compulsory pooling checklist. And they include the land testimony and exhibits of Ryan Curry and geology testimony and exhibits of Chris Canton, both of whom have previously testified before the division, and a copy of the notice letter sent on December 19th, 2024, and a copy of the affidavit of publication for December 19th, 2024. So I'd ask that exhibits A through C be admitted into the record in these cases, and that the cases be taken under advisement.
Are there any objections? Not hearing any, the exhibits in these cases are admitted into evidence. Mr. McClure, do you have any questions to follow up?
No questions, Mr. Hearing Examiner, for any of these 6 cases.
Thank you, Ms. McLean. These cases are taken under advisement.
Thank you.
I'm moving now to lines 26 for 4 different cases. 25071, excuse me, let me start over. 25027, 28, 29, and 30 for Matador Production.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe Office of Holland and Hart on behalf of MRC Hat Mesa LLC.
Good morning, Mr. Examiner. Carrie Hatley on behalf of COG Operating and ConocoPhillips.
Thank you. Are there any objections, Ms. Hatley?
No, sir.
Monitoring only.
Yes.
Ms. Vance, are there any other parties that I don't know about?
No,
Okay,
that should be
please,
it.
please proceed.
Thank you, Mr. Hearing Examiner. So with these consolidated cases, actually, before I get started, we do have, our landman has not previously testified. If you.
I would. Can you call his name and let's get him on the screen?
Sure. His name is Ethan Frazier.
Mr. Frazier?
Yes, sir.
We're going to get you sworn in and then go over your experience and education that go toward your expertise of landman petroleum. Raise your right hand, please. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Would you state loudly, would you state and spell your name for the record?
Ethan Frazier, ETHAN-FRASIER,
And what expertise are you seeking to be admitted?
landman.
Okay. What is your education that goes toward the expertise of landman?
I graduated from Texas Tech in 2023 with a bachelor's degree in energy commerce and a focus in petroleum land management. During my time at Tech, I interned at ConocoPhillips Company as a land negotiator intern under their New Mexico asset team. After my internship at ConocoPhillips, I worked part-time at Angelo and Donahue Oil and Gas Properties, where I ran courthouse documents and assembled title run sheets. Since graduation, I've been a full-time landman at Matador, working both Texas and New Mexico, Delaware Basin assets. My responsibilities include acquisitions and divestitures, negotiations, due diligence, and day-to-day land operations. I'm also involved in the AAPL and DAPL associations.
Okay, and how long have you been at Matador?
Just over a year and a half.
Okay, thank you. So you are hereby qualified as an expert in landman matters before this division. Thank you. Ms. Vance.
Yes. And before I go through the materials, Mr. McClure did reach out requesting a updated pooling exhibit. I received those from Matador yesterday afternoon. I have not had a chance to file those amended hearing packets, so I will do that this afternoon. I think he requested that where we just had the voluntary interest combined, he wanted to see that broken out. And so we will file.
Do you have a copy of that on your computer?
I do.
Can you share your screen with Mr. McClure and show him what you're going to be filing?
Sure. Give me 1 second. So you can see right here, this is the box that we have now broken out to show that voluntary interest.
Can you make it bigger?
Sure.
Okay, let's give Mr. McClure a minute to look at it.
And I have one of these for each of the cases. So
let's just give Mr. McClure a minute.
Mr. Hearing Examiner, I didn't add up the numbers, obviously, but this looks correct and appropriate to what I'm asking for.
Okay, perfect. Thank you, Mr. McClure. Ms. Vance, please proceed.
thank you, Mr. Hearing Examiner. I'm going to stop sharing my screen. So in these consolidated cases, the lands involved all are related to the east half of sections 14 and 23, Township 21 South, Range 32 East, and that's in Lee County. And then I'll just run through each of the cases. Case number 25027 is the east half, and that's a Bone Spring case. And the wells related to that case are the Blue Chip 14 FedCom 522H, 551H, and 601H. And then case number 25028 is again, the east half, but this is a Wolfcamp Oil case, and that is the well involved there is the Blue Chip 14 FedCom 702H. Then we have case number 25029, which is the west half of the east half. And the wells involved there are the Blue Chip 14 FedCom 524H, 553H, and 603H. And that is a Bone Spring spacing unit. And then lastly is case number 25030, which is again the west half of the east half. But this is Wolfcamp Oil, and the well there is the Blue Chip FedCom 704H. In these cases, we have included with our hearing packets a copy of the application, the compulsory pooling checklist, as well as the self-affirmed statement of landman Ethan Frazier and geologist Anna Thorson. And Mr. Frazier's exhibits, we include all the requisite sub-exhibits. And then Ms. Thorson's statement, we also include the geology exhibits that are required. And then lastly, we have Exhibit C, which is my self-affirmed statement of notice with a sample letter that was timely mailed on December 20th, 2024. And then the Exhibit D, which is the affidavit of notice of publication For cases 25027 through 25028, that was published on December 19th. And then case numbers 25029 and 250330, the affidavit was published on December 22nd. And unless there are any questions, I would ask that the cases be taken under advisement at this time.
Mr. Examiner, if I may, just for the record, when the revised exhibit packets are submitted, we just wanted to ensure that on behalf of COG Operating and ConocoPhillips that we've been removed from the pooling.
Yes,
Let's hear from Ms. Vance.
I just double checked them again and confirmed COG is not being pooled.
Thank you, sir.
Thank you. Okay, are there any objections to these exhibits? Not hearing any, your exhibits are admitted into evidence. Mr. McClure, do you have any questions for these 4 cases?
Mr. Hearing Examiner, I have no more questions for any of these 4 cases.
Okay, so Ms. Vance, I would say these cases are taken under advisement, but I need to leave the hearing record open to receive your amended exhibits. When would we receive that?
This afternoon.
This afternoon, with a cover letter?
Yes, with a
Okay.
cover letter
Very good.
and a
Once we-
smile.
Once we receive the amended exhibit packet, the hearing record will close and these 4 cases will be taken under advisement.
Excellent. Thank you.
All right, thank you. I'm now on number 30 on our docket. This is Riley Permian Operating LLC. It is 3 cases, 250, 47, 48, and 49. And your appearance, please.
Good morning, Mr. Examiner. Miguel Suazo with the Santa Fe Office of Bating Wozniak, representing Riley Permian Operating.
Thank you.
Mr. Examiner, Dana Hardy on behalf of Spur Energy Partners.
Spur, thank you. Okay, Mr. Suazo, do you know of any other parties?
I do not.
Okay. Mr. Suazo, there are some issues with these cases, and I believe we're going to have to move them to the March 13th docket, giving you time to resubmit exhibits with corrections. It seems as though there were issues that prevented the technical examiner from reviewing the exhibits. So I'm going to ask Mr. McClure to give you a rundown of those. Mr. McClure?
Thank you, Mr. Hearing Examiner. I know I also sent an email to Mr. Zazo in these cases as well.
Does your email give him a full list of the issues with the exhibits?
It does, Mr. Hearing Examiner.
Okay.
Do you want me to run through them, or do we just want to ask Mr. Zazo if he understood everything?
Let me go to Mr. Suazo and ask him.
So we received the email from Mr. McClure and we resubmitted the exhibits with the corrections that he requested.
Ah, so you've already resubmitted them.
We have. We did that yesterday.
Mr. McClure, were you aware that Mr. Suazo resubmitted the exhibits?
Well, I'm just now looking at the case file. I do
Okay.
see the exhibits in there, but I have not had a chance
Right.
to.
Okay.
Yeah.
All right, that makes sense. So, Mr. Suazo, what we might do is we might put these cases to the end of today's docket, if that works for Mr. McClure, and I can't guarantee that he'll have time to review the exhibits until the end of the docket, but we can at least try
That'd be great.
to do that. So, Mr. McClure, unless you object, I'll move these 3 cases to the end of our docket. And if you do have time to review them, we'll hear them. And if you don't, we'll just move them to the next docket.
Thank you, Mr. Hearing Examiner.
Okay, very good. Okay, so we're in recess on those 3 cases, Mr. Suazo.
Okay.
Let me turn some pages. Moving to number 33 on our docket, it is 4 cases brought by Mewbourne Oil, 25055, 5657, and 59. And should have appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewbourne Oil Company.
Ms. Bennett?
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating, and I'm also entering my appearance on behalf of Coterra Energy, which acquired Avant on January 17th, 2025.
And you withdrew your objection.
We did, but we're preserving our right for de novo review.
Thank you. Are there any other entries of appearance?
Yes, good morning, Mr. Examiner. Carrie Hatley on behalf of ConocoPhillips, entering an appearance in case number 25059 only.
Okay, are you monitoring?
Yes, just
Okay.
monitoring.
Thank you. Ms. Vance?
Yes, Mr. Hearing Examiner. And before I get started, we do have I have our
Expert.
landman who has not previously testified.
Would you call him to the screen?
Yes, Mr. Brock Dixon. I just sent him an email, so I think he should be on there.
Yes, I'm here.
We're looking for you. Is your, there you are up top. Okay. Okay, Mr. Dixon, I don't know if you have been on for the earlier part of this docket, but what we're going to do is get you sworn in and then have you go over your education and expertise. So are you ready?
Yes, sir.
Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
State and spell your name for the record.
Brock Dixon, BrockDixon.
Okay, you can put your hand down, sir. Okay, so you're seeking to be admitted as an expert in what field?
Land?
Okay, so petroleum landman?
Yes, sir.
Okay, what education do you have that goes toward that expertise?
I graduated at Texas Tech University, an AAPL accredited school with a degree in energy commerce in May of 2023.
Okay.
During my time,
There's a
During my
delay,
time.
so we're going to have trouble here, but go ahead.
So during my time at Texas Tech, I interned with Mewburn Oil Company in the summer of 2022. Started full-time after graduation. I began full-time at our company's headquarters in Tyler, Texas, where I calculated and set up billing and revenue decks. I've since been transferred to Midland. Here I work closely with other landmen, geologists, and engineers to put together prospects. I run title, determine ownership, negotiate and prepare leases, agreements, and assignments with other companies. Through all this, I prepare my assigned acreage to be developed while complying with federal and state rules and regulations.
What's your current title?
Landman.
Okay. All right. Thank you, Ms. Dixon. From here on in, you are considered an expert in landman petroleum field before this division. Ms. Vance.
Thank you, Mr. Hearing Examiner. So in these consolidated cases, it involves the lands covering irregular sections 19 and 30 of Township 18 South, Range 33 East, and that's in Lee County, New Mexico. All of these cases are in the Corbin Bone Spring South Pool, and the pool code is 13160. So in case number 25055, this is Mewburn is pulling the west half of the west half of that acreage, and the well dedicated there is the Mysterio 3019 Fed 521H. And then case number 25056, Mewburn is pulling the east half, the west half, and initially dedicating that to the Mysterio 3019 Fed 523H. And then case number 25057, Mewburn is pulling the west half of the east half and dedicating that to the Mysterio 3019 Fed 525H. And then lastly is case number 25059, and Mewburn is pulling the east half of the east half and dedicating that to the Mysterio 3019 Fed 527H. And I will note that we did file some updated exhibits. Mr. McClure did ask for us to swap out, I believe it was in case number 25059, we had the incorrect application. And so we swapped in the correct application there. And then we also updated the structural cross section to show the updated lateral direction based off of, and this is discussed in Mr. Dixon's statement, based off of discussions with the BLM. The BLM required Mewburn to basically flip the lateral. And so now these wells will be going south to north, and as opposed to what was initially provided in the proposal. And Mr. Dixon did provide, and it is included, a updated letter to interest owners explaining that change in the lateral direction. So in each of these cases, we have included a copy of the applications, the compulsory pooling checklist, as well as the self-affirmed statement of landman Brock Dixon and geologist Charles Crosby. And then Mr. Dixon, we have included all the required exhibits for land. And then Mr. Crosby, we have included the required geology exhibits. And then lastly is my Exhibit D, which is my self-affirmed statement of notice with a sample letter that was timely mailed on December 20th, 2024. And then the notice of affidavit of publication, which was timely published in each of the cases on December 24th, 2024. And actually, I believe my self-affirmed statement is not Exhibit D, it is E. I apologize. Unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record, and I stand by for any questions.
Are there any objections? Your exhibits are admitted into evidence. Mr. McClure, are there any questions in these 4 cases?
Mr. Hearing Examiner, I do have some questions for the landman.
Mr. Dixon?
Yes, sir.
Okay, Mr. Dixon, I remind you that you are under oath. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Dixon, I'm looking at your statement, paragraph 6, found on page 10 of 36 of the new exhibit for the first case. Are you there with me, sir? Are you able to share, Ms. Vance?
I can. Give me 1 second just to make it easier.
Yes, ma'am, that's exactly what I'm looking at. Mr. Dixon, on here you reference, I'm assuming, okay, let me back up. When you are referencing a change in the surface and bottom hole locations for the proposed wells, what are you referring to?
So the surface location originally was in section 30 and the bottom hole was in 19. But we flipped the surface hole to the southwest of section 18, or the surface hole to the southwest of section 18 and the bottom hole on section 30.
And are those changes reflected on both the compulsory pooling administrative checklist and the C-102s that's in this exhibit packet?
Yes, sir.
Okay, so then are there going to be any changes from what's on the compulsory pooling administrative checklist and the C-102s?
I don't believe so. No, sir.
When you say you don't believe so, is that because you don't know what future planning might be, or that you haven't had a chance to review, I guess?
There shouldn't be a change. No, sir. Not a chance to review.
Oh, you said you have had a chance to review. Is that correct, sir?
Yes, sir.
Okay, thank you, Mr. Dixon. No further questions, Mr. Hearing Examiner.
Mr. McClure, were those answers sufficiently concrete for you?
Yes,
Okay.
I'm satisfied with the
Okay.
responses I've received.
Thank you, Mr. McClure. May we take these cases under advisement?
Yes, I believe yes, we can.
Okay, thank you, Ms. Vance.
Thank you.
Okay, we are now moving to numbers 60 on our, number 37 on our agenda. These are Permian Resource Operating LLC cases. There are about 7 of them, 25060 through 66. And your appearance, please.
Jackie McLean on behalf of Permian Resources, and it's for case numbers 25060 through 25067.
067.
Correct. It's number 44.
Thank you. Yeah, I didn't see 67. Thank you. Are there any other entries of appearance?
There is, EOG has entered an appearance. I don't know if she's on. They don't object, but
I'm sorry, you're looking at someone?
no, I'm looking to see if
Oh.
Jordan's around.
Jordan
EOG,
Kessler?
yeah, EOG entered an appearance. They didn't object. Oh, there.
Ms. Kessler, are you with us?
I am Mr. Hearing Examiner. Can you guys hear me now?
Mm-hmm.
Here we are. Thank you. This is EOG Resources. And as I could hear Ms. McLean saying, EOG does not object to this case going forward. Thank you.
Okay. Ms. McLean?
Thank you. In case numbers 25060 through 25067, Permian Resources seeks an order pulling all uncommitted interests in the Bone Spring and Wolf Camp formations in sections 21 and 22, Township 20 South, Range 28 East in Eddy County. And these units will be dedicated to the Taipan wells. We submitted amended exhibit packets yesterday at the request of Mr. McClure. And those include the land testimony and exhibits of Ryan Curry and the geology testimony and exhibits of Chris Canton, both of whom have previously testified before the division. The notice exhibit includes a copy of the notice letter sent on December 16th, 2024, and a copy of the affidavit of publication for December 19th, 2024.
Ms. McLean?
Yes.
The amended exhibit packets are only in certain cases, right?
That's correct.
Which ones?
Yes. Let me give you the numbers here.
I mean, I believe it's 64
The
through
Wolf
67, but
Yes, it's the Wolf Camp cases, which are case numbers 25064 through 67.
and did you understand that an NSP will be required prior to producing the wells?
Yes,
Okay.
and we reflected in the checklist that we will be applying administratively
Okay.
for that, so that we could proceed forward with the pooling.
Okay, perfect. Please proceed.
Thank you. That's all for me,
Okay.
unless there are questions, and I ask that exhibits A through C be admitted into the record for these cases and that they be taken under advisement.
Are there any objections? Not hearing any, your exhibits are admitted into evidence. Mr. McClure, any questions on these cases?
Mr. Hearing Examiner, I have no questions for any of these 8 cases.
Okay, your cases are taken under advisement. Thank you, Ms. McLean.
Thank you.
I'm now moving on to number 45 on our docket and 46. This is COG operating 25070, 25072. Enter your appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of COG Operating.
Are there any other parties that you know of?
I don't believe so,
Okay.
no.
Please proceed.
Yes, so both of my experts have not appeared before the division, and I did let them know that we are up, so they should be available.
Can you call them?
Yes, so we have Carolyn Frederick,
Mhm.
and then we have Tyler Patrick.
Perfect. Would you both raise your right hands, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, let's, Mr. Patrick, I didn't hear you affirm. I still don't hear you, sir. Mr. Patrick, I think you need to work on your microphone while I speak to Ms. Frederick. Ms. Frederick, would you state and spell your name for the record, please?
Yes, sir. Caroline Frederick, Caroline Frederick.
Okay. What area of expertise do you seek to be admitted as an expert before this division?
And petroleum land.
Land, excellent.
Yes, sir.
Okay, what education do you have that goes toward that field?
I have a bachelor's degree in energy commerce with a focus in petroleum land management. In 2022, I interned with ConocoPhillips in land, and upon graduation in 2023, I started with ConocoPhillips in land on the Delaware Basin, New Mexico team.
Okay, perfect. And what work have you done with ConocoPhillips since graduation?
Putting together new units, working various deals with other companies, and working with the BLM and the NMSLO on maintaining various agreements.
Okay, and what is your position now with ConocoPhillips?
Associate land negotiator.
Okay, all right. From here on in, Ms. Frederick, you are considered an expert in petroleum land before this division. Now let's see about Mr. Patrick. Did you get your microphone to work?
Can you hear me now?
Yes, I can. Thank you. So do you affirm what you swore to or what I asked you to swear to before?
I do.
Okay, very good. Would you lay out your, well, first of all, what field of expertise do you seek to be admitted before this division?
Geology.
Perfect. What education do you have toward that?
I have a bachelor's degree in geology with a petroleum emphasis from Western State College of Colorado, and I have a master's degree of geology from UTPB.
Okay. And when did you achieve that master's?
2015.
15. Okay. And what have you done since then, work-wise?
I've worked for multiple operators, Apache Corporation. I've worked for Grit Oil and Gas. I've worked for Maverick Natural Resources and also Sheridan Production Company.
Okay. Can you tell me what you've been doing for those different entities?
Yes, sir. I've been working on prospecting for oil and gas, both in conventional and unconventional reservoirs throughout the majority of the lower 48. I worked specifically in Lee County for Apache Corporation, drilling Bone Spring wells back in 2012. And then I've worked in Lee County for a mining operation looking for polyhalite.
Okay. And you seek to be an expert in geology. What is your title now?
Staff geoscientist.
I'm sorry, I didn't understand you.
Staff geologist.
Staff geologist. For what company?
ConocoPhillips.
ConocoPhillips. Okay. Okay. Thank you, Mr. Patrick. You are hereby an expert in that field before this division. So let's go back to Ms. Vance.
Thank you, Mr. Hearing Examiner. And this was another one. Mr. McClure did reach out and ask for us to include the API numbers for the cross-section wells, which I added, and we had those swapped in yesterday. So the correct hearing packets should be uploaded and were sent to Mr. McClure. So,
Mr. McClure, did you get it?
Yes, sir, I did, Mr. Hearing Examiner, and they are also in the case file.
Okay, thank you.
May I proceed?
Yes, please.
Okay. So in case number 25070, COG is seeking to pool the west half of sections 24 and 25. And that is in Township 25 South, Range 34 East, and that's Lee County, New Mexico. And that's and the pool there is the Fairview Mills Pool Bone Spring, and the pool code is 96340. And COG seeks to dedicate the Pitch Blend 24 TAC 25 Federal Com 606H. And then in case number 25072, COG is pooling the west half of sections 24 and 25, same township and range, Lee County, New Mexico. And that involves the Doggy Draw Wolf Camp pool, and the pool code is 17980. And dedicating that to the Pitch Blend 24 TAC 25 Federal Com 705H. And that is a proximity well, allowing for that enlarged spacing unit. So in each of the hearing packets, we have included a copy of the application, the compulsory pooling checklist, as well as the self-affirmed statement and exhibits of Carolyn Frederick and geologist Tyler Patrick. And then lastly is my statement of notice with the sample letters that went out on December 20th, 2024. And then the affidavit of notice of publication, which was timely published on December 19th, 2024. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Are there any objections? Hearing none, the exhibits are, well, the amended exhibit packet is admitted into evidence. Mr. McClure, any questions?
No questions for either of these cases, Mr. Hearing Examiner.
Thank you, Ms. Vance. The cases are taken under advisement.
Thank you.
Now we are on line 47 of our agenda, 25076, Permian Resources Operating LLC. It is joined with 77 and 78. And should appearance, please?
Jackie McLean on behalf of Permian Resources.
Thank you. Are there any other parties that you know of, Ms. McLean?
There are not.
Okay, please proceed.
Thank you. In these cases, Permian Resources applies for an order pulling all uncommitted interests in the second Bone Spring interval of the Bone Spring formation, underlying the north half, south half, and north half, south half of section 25, and the north half, northeast quarter, south half, northeast quarter, and southeast quarter of section 26, township 20 south, range 28 east in Eddy County. And these units will be dedicated to the boomerang wells. Permian Resources submitted amended exhibit packets yesterday at the request of Mr. McClure to correct one of the geology exhibits, exhibit B4. And the amended exhibit packets include the land testimony and corresponding exhibits of Ryan Curry and geology testimony and exhibits of Chris Canton, both of whom have previously testified. It also includes a copy of the notice letter that was sent on December 16th, 2024, and a copy of the affidavit of publication for December 19th, 2024. And I ask that the exhibits A through C be admitted into the record in these cases and that they be taken under advisement.
Are there any objections? Hearing none, your exhibits are admitted into evidence. Are there any questions, Mr. McClure?
No questions for any of these three cases, Mr. Hearing Examiner.
Thank you, Mr. McClure.
Thank
These
you.
cases will be taken under advisement, Ms. McLean.
Thank you.
All right, we're moving on to number 50 on our docket. This is Apache Corporation's amendment cases 25082, 83, 84, and 85. And show appearance, please.
Good morning, Mr. Examiner. Dina Bennett on behalf of Apache Corporation.
Thank you. Are there any other parties that you know of, Ms. Bennett?
Not that I'm aware of.
All right, please proceed.
Thank you. In these four cases, Apache seeks to reopen its orders to amend them to add previously unidentified or unpooled parties. And in our exhibit materials, I've included tab A, the declaration of Blake Johnson, a landman with Apache, and he's previously testified before the commission or before the division and the commission. And his exhibits have been, or his credentials have been accepted as a matter of record. In each case, we've also included a list of the parties to be pooled. And in these cases, Apache is only seeking to pool overriding royalty interest owners. The additional parties are only overriding royalty interest owners. And then tab B in each case is my declaration, and it includes a sample notice letter, which was mailed on December 16th, the certified mailing tracking list, and the affidavit of publication, which was done on December 21st, 2024.
I have a question, Ms.
Yes.
Bennett. So there are four different orders, 23091, 92, 93, and 94, that you're seeking amendment. When were those orders issued?
Those orders were issued, the first one that I turned to was issued March 13th, 2024.
Okay, so they're all timely amended as far as you're representing?
Yes, and also we're not seeking an extension of time. I don't know the status of the wells, whether they've been drilled, but I'm assuming that they will have been or will be timely drilled.
Okay, so you're not seeking an extension of time, you're just seeking to add additional parties.
That's correct.
To the pool, okay. And these are parties that were located from, how did they come up?
Apache ran some additional title. They updated their title after the cases originally went to hearing and identified these handful of overrides that hadn't been pooled.
Okay, all right. Okay, are there any objections to the exhibits in these cases? Not hearing any, your exhibits are admitted into evidence. In a case where you don't extend, or you're not requesting extension of time, is there good cause necessary to extend amend the orders?
No, there's not.
Okay, all right. Mr. McClure, are there any questions?
Mr. Examiner, I have no questions for any of these 4 cases.
Perfect. These 4 cases are taken under advisement. Thank you, Ms. Bennett.
Thank you.
We're now going on to Spur Energy Partners. This is a compulsory pooling case for 25092. And your appearance, please.
Jackie McLean on behalf of Spur. And
And it's-
there are no other parties.
Perfect. And it's not joined to any other case, is it?
No, it's just a solo case.
Perfect.
Rare.
Please proceed.
Thank you. In this case, Spur seeks an order pulling all uncommitted interest from the top of the Yeso formation to 5,000 feet measured depth, underlying a 320-acre standard horizontal spacing unit comprised of the north half of Section 12, Township 17 South, Range 28 East in Eddy County. And the unit will be dedicated to the Fat Tire 12, Federal Com 20H, 50H, and 70H wells. Spur submitted exhibit packets for this case, an exhibit packet for this case, which includes the land testimony and exhibits of Rhett Dalton and geology exhibits and testimony of Matthew Van Wee, both of whom have previously testified before the division. The notice exhibit also includes a copy of the notice letter that was sent on December 17th, 2024, and a copy of the affidavit of publication for January 4th, 2024. So if there's any questions, I'm happy to answer them. And I ask that exhibits A through C be admitted into the record in this case and that the case be taken under advisement.
Are there any objections? Not hearing any, your exhibits are admitted into evidence. Mr. McClure, any question on this case?
Mr. Hearing Examiner, I will have a question for the landman, and also I'll need a pool correction with Miss McLean at the end of it.
Okay, so are you ready for the landman?
Yes, I am, Mr. Hearing Examiner.
Okay. What is the name of the landman?
Rhett Dalton.
Okay. Let's get you on the screen, sir. Okay. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. Would you state and spell your name for the record?
Rhett Dalton, R-E-T-T, Dalton, D-A-L-T-O-N.
And as Ms. McLean said, you have been recognized as an expert before this division. Is it correct?
Yes, sir.
In what field?
Land.
Land. Okay. Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. McLean, if I could get you to share your screen and bring up page 6 of 75. This should be the statement for Mr. Dalton.
Page 6.
Yes.
Ms.
Yep,
McLean.
and that,
Ms. McLean, what is this exhibit number?
This is exhibit A, the self-affirmed statement of Mr. Dalton.
Is it marked as an exhibit number?
It is marked as exhibit A, on
Just
page
A.
5, just A,
Okay.
just A.
Mr. McLean, Mr. McClure, please proceed.
thank you, Mr. Hearing Examiner. Mr. Dalton, if I can direct your attention to your paragraph 8 there, where you're referencing a death severance within the unit.
Yes.
Now, you also reference here the top of the Yezo Formation at 4,257 feet measured depth as found in Chica Cat Federal Com number 1. Do you see what I'm referring to?
Yes, I do.
Is there depth severance at that depth?
Is there a depth severance at the top of the Yeso? Is that your question?
Yeah. Yes, that is my question.
I don't believe so, not at that particular interval. But we're looking to just pool just into the Yeso.
Okay, so this depth here was included just to tell us where the top of the Yezo is.
Yes,
Then. Is
yes,
that
sir.
correct?
Yes, sir. Yes, sir.
Okay, thank you, sir. Now, towards the end of this paragraph 8, you also reference a 5,000 feet measured depth. Do you see what I'm referring to?
Yes, sir.
Is that where the depth severance is then?
There is a depth severance based on based on some overrides, and then there. So that it really pertains to an override depth severance within the YESO. Within the YESO.
And is that also the base at which you're requesting to pull?
Yes, sir.
Okay, now is that 5,000 feet measured depth? Is that also based upon the Chickacat Federal Com number 1?
To my knowledge, it would be, yes, sir. That's what I'm. That's what I think that means. Well, it's a stratigraphic equivalent.
Yes, but the 5,000 feet, is that 5,000 feet measured depth at the Chickacat Federal Com number 1?
Oh, that I'm not positive.
Well, this statement, it was put together by yourself or under your guidance, is that correct?
Yes, with other help here in the office, yes.
Okay, so you do not know where the 5,000 feet measured depth is coming from then?
Well, I guess is your question the genesis of the 5,000 foot severance? Is
let me re-ask my question. What is that 5,000 feet measured depth in reference to? Do you understand my question?
yes. There's a as I mentioned, there's an override that there's from the top of the YESO to 5,000 feet that some parties have an interest in, and then those parties and additional parties have an interest in an override below 5,000 feet from previous depth severances in assignments.
You know, in those assignments, is it correct that the 5,000 feet would have been in reference to maybe a specific well or a specific location? Or do you know what that might be referenced to within those assignments?
That's what I'm not positive to on that.
Okay.
If it's just a depth, I don't know. I'd have to go back and look to see what that 5,000, if it was just a depth severance, that 5,000 feet for that particular assignment for the lease, or if it was referring to something else.
Now, Mr. Dalton, it looks like there is wrote in on the geologist's cross section. Do you think your geologist might have more information on the depth severance?
He would know. He could talk better about the Cat Federal well, but as far as legal aspects, if you're asking for a previous document or an assignment, I don't think he would have that knowledge.
Okay, that makes sense, Mr. Dalton. Mr. Hearing Examiner, I have no more questions for Mr. Dalton at this point, but I will request that they conduct some research to figure out where that 5,000 was referenced from. And my recommendation would be that we continue the case to give us time to review that additional information.
Okay, Mr. McClure, I agree. All right, so Ms. McClure, we're going to
But I think we
recess.
needed a pull and full code correction. Is that correct, Mr. McClure?
Yes, that's also correct. And it would likely be appropriate to have them correct that at the same time. Is that correct, Mr. Hearing Examiner?
Yes.
Let me get my other screen open. Miss McLean, this is kind of a messy section when it comes to the pools, but the correct pool should be pool code 96718.
96718.
That's correct, and that's the Local Hills, Glorieta, Yezo.
All right, the Loco Hills Glorieta Yeso Pool 96718.
Yes, ma'am. And if we can just have that submitted with an amended exhibit packet prior to the next hearing date.
And then you'd like us to, I guess if the 5,000 feet measured depth is just due to the conveyance and the lease depth severance, and not because it's referencing a specific well, do you want just an extra sentence about that in the testimony?
I think we're going to need a full statement in regards to that rather than just a simple sentence. If you provide the documents, that could also add some to it. I wouldn't necessarily think that would be completely necessary, but I do want to know where that 5,000 feet is coming from. Maybe it's reference to a specific quarter section rather than a well, although the addition of measured depth would make me think it's reference to a specific well.
All right, we will do that.
So, Ms. McLean, when do you believe you will be ready to continue this hearing?
I mean, certainly by the next hearing docket.
Well, I mean, if it's just if
you'd let us go at the status conferences.
we may be able to add this to, we have a special docket. We have a special docket on the 18th. If I'm not mistaken. Freya, do we have any room on any of our special dockets to add this case?
On February 18th, I think we can add it if it's going to be quick.
Yes, I think it should be. But if we're just submitting an amended exhibit packet, it should be fairly quick.
And your witness would need to be available to clarify anything that Mr. McClure has to ask.
Mr. Dalton, do you think that's possible to go next Tuesday, February 18th?
Yes.
Okay, Mr. McClure, would that work for you?
Oh, yes, that should work, Mr. Hearing Examiner.
Okay, let me look at that docket just to see what other cases are on there and see where we can put this case.
Okay.
And Mr. Hearing Examiner, we are adding a new set of hearings by affidavit. I just spoke with John Garcia and he agreed that we could add some of Ms. Vance's cases.
To the February 18 docket?
Yes.
Okay.
So it'll be an additional set of hearings by affidavit.
How many cases are we talking about?
I think there's 3 or 4. 4.
Okay, that's fine, Ms. Jans. So let's see, we have amendment cases for Franklin Mountain Energy. They say hearing by affidavit. Are these contested, Ms. Bennett?
No, they're not.
These are not, but they're your cases.
They are.
I thought so. So we have what, 4 of your cases, Ms. Bennett?
It's either 3 or 4.
3, I'm sorry, it's 3 cases, I'm sorry. I see, we moved them due to witness availability. I see now. So we made a special deal with Ms. Chance. Okay.
I did. Thank you.
We're in the special dealing phase of our day. Okay, so compulsory pooling, we have a status conference. Looks like we have a status conference on 50, 51, 52 for Permian Resources. Are these yours, Ms. Vance? Permian Resource?
Which cases are they?
Let me just read the notes. Hold on.
I'm assuming so, yes.
This is a motion. No, I think these are the 8:30 a.m. cases for Miss Shaheen. We have a motion to strike an entry of appearance that we're hearing that
Oh.
morning at 8:30. That'll probably take about half an hour or so. So now I know what those are. Okay. Then we have a contested hearing with Avant 24774. Ms. Bennett, your case?
Yes, that's my case, and it competes with cases filed by Mewborn.
Perfect. Perfect. And who's representing Newborn? Are you Ms. Vance? Okay.
That's correct.
And do you still anticipate those cases going?
Yes, unfortunately.
Wasn't very enthusiastic.
Yeah.
Yes, Ms. Bennett.
Well, they will be at this point going forward.
Okay. All right. Sounds good. Now the 18th is 5 days away. So pre-hearing statements and exhibits are due, aren't they?
They are, and Mewborn filed its pre-hearing statement and exhibits, and Avant/Coterra filed a pre-hearing statement. We did not file exhibits due to timing constraints and other constraints, but we intend to cross-examine Mewborn's witnesses, and Coterra/Avant objects to Mewborn's cases moving forward.
And of course, you always have the ability to admit rebuttal exhibits if necessary.
Thank you.
If you can make the case for them, you know.
Thank you.
Okay. That's Mewborn. Okay, so now we're talking about adding this one case for Miss McLean.
We
So
got
Miss
to 9
McLean,
o'clock.
I think what we'll do is we will hear your case.
At 9.
We will hear your case after Miss Shaheen's motion hearing.
Perfect.
Hers is going to be at 8:30. I suspect we'll start with yours at 9 o'clock.
Okay, I can
Which-
be here at 8:30 just to.
Perfect.
honest
You never
with you.
know.
Yeah.
That's perfect. Mr. McClure, will it be Mr. Garcia, who's our technical examiner for the 18th?
It will be Mr. Garcia
Okay.
for the most part, but if we're hearing this at 9, then I might step in for
Oh,
this
perfect.
particular case, or else provide questions to Mr. Garcia. We'll
Perfect.
work that out.
That's perfect. Thank you. I appreciate it.
Yeah,
Thanks
thank
for
you.
your flexibility. Okay. Freya, does that cover the docket for the 18th? Did I get that right?
Yes.
Okay. Okay, so Ms. McLean, you will have to move your case. You will have to continue your case to the 18th. And file your amended exhibit packet with your pool code correction and this 5,000-foot issue and the depth severance from your expert, and your expert will need to be here on the 18th. I would say be here at 8:30, sir, so that in case we start a little earlier than 9, you will be available. I assume that you're hearing me, and if not, well, hopefully you'll be here. Okay, we're in recess on that case. Let's move now to lines 55 and 56 on our agenda. This is Chevron USA amendment cases 25118, 25119.
Yes. Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Chevron USA, Inc.
Are there any other parties that you know of?
No.
I have a question about the original order in this case. Can you take a look at it, or do you already have information about the order?
I can pull up the order.
I think it's R22769.
It is. I had it up earlier. Okay, I have it up.
Okay, thank you. So my question, I need some clarification as to these two cases and how they relate to 22769. So I can see that 118 is an amendment to add initial wells for. Why don't you describe, what are you asking for in 25118?
Yes, okay. So in that order relates to case number 25118. So what we are asking for is to open and amend what we originally pooled. So in the original application, which is the order you were referencing, we pooled from the base of the first bone spring to the top of the wolf camp. So in other words, the second and third intervals, bone spring intervals. And so in this case, we are opening that back up to ask to pool the entirety of the bone spring and add initial wells. And in this case, Chevron has reached voluntary agreement with all of the working interest owners. So we're only asking to pool overrides and record title.
Okay. What is the status of the drilling in this area?
What do you mean?
Okay, well, I don't know any other way of asking it. The original order was issued July of 2023.
Okay.
So
Have these wells been drilled? Is that what you're asking?
it is.
I don't know off the top of my head, but I believe we have our landman and our geologist, and I
Okay.
am sure our landman would be able to answer that question.
Okay. This case asking to amend this order was filed when?
Okay. It was filed December 18th, 2024.
Okay. And when you seek to amend an order, isn't there a time limit?
You mean in terms of the perfecting the order?
Yes.
Yes.
What is the time limit?
So it's based on the language of the order, which is you have a year to drill, and then from the date you drill, a year to complete the well.
Okay, perfect. So now my question is, because this was filed in December, which is after 1 year,
Mm-hmm.
do you see what I mean?
Yes. So again, I would have to talk with the landman just to discuss, but I don't want to make any
Sure.
assumptions.
Let's get the landman on the screen. What is his name?
His name is Douglas Crawford.
Has he been qualified as an expert?
Yes, he has.
Perfect, thank you.
Hello, Mr. Examiner, I'm here.
I see you. Would you make him bigger? Perfect. Okay. We're going to get you sworn in first. Would you raise your right hand? You swear or affirm that the testimony you're about to give under penalty of perjury is the truth, the whole truth, and nothing but the truth?
Yes,
Okay. State and spell your name, please.
Douglas Crawford, Douglas, last name Crawford, Crawford.
Okay. And who do you work for?
Chevron,
Chevron. Okay. And what is your position?
land representative.
Land representative. How is that different than a petroleum landman?
It's the same.
Same. Okay, thank you.
Yes.
Mr. McClure, are you willing to ask him some questions about the drilling under this order?
I can if you'd like, Mr. Herring.
I would, thank you.
Mr. Crawford, has Chevron drilled all the wells that were included in order R22769?
From what I'm seeing, I just took over this project. From what I'm seeing, it looks like we are drilling them currently.
So they are not currently drilled as of prior to the order's termination, which occurred 7th month, 10 day of 2024. It was not drilled prior to then. Is that correct?
That is correct.
So Ms. Vance, you have some additional information to work with now.
Yes, but I'm looking to see when they commenced drilling.
It would have been December 14th.
Of what year, sir?
2024.
Thank you.
And you know what, I may need to talk with my client because I believe, and I want to say, so as
Why don't we
Mr.
just wait? And why don't we just wait until you talk to your client?
Okay,
That way you don't have to.
I'll just say this. Mr. Crawford, I believe he took over this project and I had some previous conversation with the prior landman and I just need to go through my communications. But I believe I have an answer for you on this of,
Okay. Well, you have some time.
Thank
Why don't
you.
why don't we go into recess on these two cases?
Yeah. Mhm.
And we'll come back when you're ready.
Okay.
Okay.
Definitely.
Thank you, Mr. Crawford, Ms. Vance. Okay, I'm going to call the next case on our docket. This would be 25120. This is Permian Resources LLC amendment case.
Mr. Examiner, Dana Hardy on behalf of Permian Resources. And there are no other entries of appearance.
Perfect. This order, did you file your amendment before the order expired?
Yes, we did, Mr.
Okay.
Examiner.
Thank you. Please proceed.
So Colgate Production is the applicant here, which is a subsidiary of Permian Resources. And Colgate requests a 1-year extension of time until February 28th of 2026 to commence drilling the wells authorized by order number R23078 and also seeks to pool additional interest under the order. The extension is requested because the spud date has been delayed until May of 2025 to allow Permian Resources to obtain production results from offset acreage and ensure optimal well spacing. We've provided the affidavit of landman Travis Maka in support of the application. Mr. Maka has previously testified as an expert before the division, and he provides the standard land exhibits. Exhibit C includes my notice affidavit and associated attachments. Notice was timely sent by certified mail on January 10th and was timely published on January 18th. So with that, unless there are questions, I request that the exhibits be accepted and that the case be taken under advisement.
What is the good cause?
The good cause is that Permian Resources is evaluating production results from offset acreage to ensure optimal well spacing.
Okay. Are there any objections? Not hearing any. Your exhibits are admitted into evidence. Mr. McClure, are there any questions for this case?
Mr. Examiner, I have no questions for this case.
All right, this case is taken under advisement. Thank you. We're now moving on to a unit agreement case brought by Texas Standard Operating LLC.
Mr. Hearing Examiner, can I ask one question related to my two prior cases?
You want to ask me a question or Mr. McClure a question?
You.
Go ahead.
So it's only one of my cases that's impacted.
Yes,
So
118.
can I at least move forward with my other case if possible? Obviously not now if we're moving forward with the other case, but could we at least get that?
So 119, it was unclear whether 119 was also dependent upon the order or not.
It is not.
It's a standalone case.
It is.
It is a standalone.
It
case.
is. Yes.
Okay. Mr. McClure, did you review 25119?
Yes, I did, Mr. Examiner.
Okay. And are you in agreement that 25119 is a standalone case?
I am in agreement.
Okay, excellent. Okay, so before we call 25126, which I was in the process of calling, let's recall 25119. Ms. Vance, would you like to present the case?
Yes, and I apologize for interrupting.
Go ahead.
Thank you. So in case 25119, Chevron USA seeks to pool the east half of sections 14 and 23, Township 24 South, Range 31 East, and that's in Eddy County, New Mexico, and that is and that will be dedicated or in the Wolf Camp, Purple Sage Wolf Camp, and the pool code is 98220, and the wells there are the SND 1423 FedCom 622H, 623H, and 624H. We've included a copy of the application, compulsory pooling checklist, and the self-affirmed statement of Douglas Crawford and Leah Johnson, Mr. Crawford is the landman, Ms. Johnson is the geologist. They have both testified before the division. We've included because we're only seeking to pull the overrides and record title, we've only included the C-102 and the land track map and the pooled parties. And then we've included the required geology exhibits. And then we also have my statement of notice with a sample copy of notice that went out on December 24th, 2024, and then the affidavit of notice of publication that was timely published on January 30th, 2024. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that this case 25119 be taken under advisement at this time.
Are there any objections? Not hearing any. The exhibits submitted are admitted into the record. Mr. McClure, do you have questions?
Mr. Hearing Examiner, I do not have questions, but I do have 2 requests for Ms. Vance.
Okay, go ahead.
Thank you, sir. Ms. Vance, the first one, relatively minor, but since we're submitting an amended exhibit packet anyway, we might as well get it corrected. On your compulsory pooling administrative checklist, you see where it has the setback rules in the pooling area?
Let me get there.
Yes, ma'am.
Yes.
Included there, you have statewide rules, but this is incorrect. The Purple Sage
Got it.
Wolf Camp. Okay, thank you. In addition to that, the geologist cross-section in Exhibit D3, page 26 of 32, does not include API numbers.
I can correct that.
Okay, thank you, Ms. Vance. I have nothing further for this case, Mr. Hearing Examiner.
Okay, so the notice for this case is not affected by the notice in 25118.
I agree with that, Mr. Hearing Examiner. It is not affected by the notice. If you were asking me, I don't think it is, but.
Okay, very good. Okay, so Ms. Vance, once you submit an amended hearing packet with a cover letter to show the 2 things that Mr. McClure asked you for, we will take this case under advisement.
Thank you.
All right, thank you. Now, let's go back on the record in 25126. It is line 58 in our agenda. And your appearance, please.
Good morning, Mr. Examiner. Dina Bennett on behalf of the applicant, Texas Standard Operating New Mexico LLC.
Thank you.
And Mr. Examiner, Dana Hardy on behalf of BTA Oil Producers LLC.
And what is your role here this morning, Ms. Hardy?
BTA entered an appearance and had initially objected based on the exclusion of certain acreage within the unit, but Texas Standard agreed to remove that acreage, and so we've withdrawn our objection.
Very good.
On the condition that it's removed.
I saw the plats and I did see that they had changed and reduced the size of the unit. Is that correct, Ms. Bennett?
That's correct.
Okay, I thought so. So no objections, Ms. Hardy?
That's correct.
All right, very good. Ms. Bennett, are there any other parties?
Not that I'm aware of.
I think there
Excuse
might
me.
be.
Sorry to
Oh, right,
interrupt, Ms.
EOG.
Bennett. This is Jordan Kessler on behalf of EOG. We're just monitoring this case.
Okay. And Mr. Suazo?
Yes, Mr. Examiner, Miguel Suazo on behalf of XTO Energy Permian. We originally objected and we've since withdrawn the objection, similar to what BTA did between them and TSO.
So the reduction in acreage satisfied you?
Correct.
All right. Are there any other entries?
Yes. Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Matador.
Any objection?
No.
Okay. Ms. Bennett?
Thank you. This is a request by Texas Standard Operating for the division to grant a voluntary exploratory unit. We've included in our materials the self-affirmed declaration of Matt Roberson. He's previously testified before the division. And he's a landman. We also included the self-affirmed declaration of David Ensminger. He's previously testified before the division and he's a geologist. And then the final set of exhibits are my notice materials. And we sent the notice letter on January 23rd and timely published on January 28th. And just for a little bit of background, this is a voluntary unit. It's comprised entirely of state lands. And OCD approval of the unit is a prerequisite to the State Land Office completing its review. And the State Land Office has issued a preliminary approval and is in favor of this unit. So with that, I would ask that the exhibits in case 25126 be admitted into the record. And I'm happy to answer any questions you might have.
Okay, are there any objections? Hearing none, your exhibits are admitted into evidence. Let's see if we have some questions. This is your case. So we have two technical examiners with us today. One is Millian Geber-Michael. Good morning.
Good morning, Mr. Hearing Examiner.
And do we also have Phil with us too?
Yes, yes, sir.
Mr. Getz, are you with us?
Mr. Examiner, if I could clarify, I believe Mr. Geber-Michael and Mr. Getz are the examiners for the next case, Raz Oil.
25081.
Oh,
That's right.
that's why I asked. Would you turn off your microphone then?
Somewhere a little bit.
Thank you. All right. Mr. McClure, do you have any questions in this case?
Mr. Hearing Examiner, this is the case with the potential notice inquiry.
Yes, it is.
Do you want me to
Okay.
follow up with questions
I-
on that or? Oh,
I can start. And then we can go from there. So Ms. Bennett, we were looking at the notice provided in this case. And let me pull up the application. And this was a case that was previously filed under 24985. Is that correct?
That's right,
Okay, good. And why was that case dismissed and refiled?
because there was a typo in the legal description.
Okay, all right, so here. In the I need to pull up the correct case, so give me one moment. In all of the documents, including the application, you have the following description in Township 18 South, Range 36 East. You say sections 4-6, blank. Then you say section 7 through 10, all. Sections 15 through 17, all. And then in sections 18 and 21, you specify particular sections. But you don't specify what parts of sections 4 through 6 you are including in the legal description.
Yes, I see that now. And it was intended to be all, which I think by virtue of not including the word all, the default would be that it's all.
I thought you might make that up. Okay. Are there any objections? I see Ms. Vance is typing furiously. Ms. Vance, were you listening to this issue?
No, I'm trying to resolve my issue.
I figured you were. I figured that's what you were doing over there. Ms. Hardy, is there an objection?
No,
No.
BTA does not object.
Okay. And just for my own benefit, why is there no objection to this?
Well, because I think the exhibits clarify the acreage that is being included in the unit.
But we're specifically talking about notice.
Right.
So if you didn't think this case applied to you, you wouldn't look at the exhibits, I would assume.
Correct.
All right. Plus the exhibits are submitted long after the notice would have had to have been put out there. So I've heard Ms. Bennett's argument as to the default for the word all. So why do you feel that this notice is valid?
Well, I think BTA understood what acreage was included.
Okay.
So from our perspective, I don't think it's a problem.
Okay,
I don't know if it's a problem with respect to public generally, but
Sure,
not from
but-
BTA's perspective.
that's what I was asking.
Yes,
For your, on
yes,
behalf of your
Thank
client.
you.
Ms. Vance, did you hear any of what was going on? No.
Nope. But I understand that we're talking about, I'm sorry, I apologize. That's terrible. I am partially listening. I understand that you're talking about a notice.
A notice issue.
issue.
The legal description in this case has section 4 through 6, full : blank. Whereas other sections, it says all, or it says a particular subpart of that section. This has nothing. And I want to know if there's an objection to the legal description in this case.
For Matador, no,
Okay.
no objection.
Perfect. All right. Okay, Mr. McClure, how do you want to proceed? Ms. Bennett's argument is there's a default to all, so even if there's nothing there, it means all. So the word all is not a prerequisite to designate the entire section. How do you feel about that?
I would say that I wouldn't agree with that the default
Okay,
is
so you're
all.
not
I think all
comfortable.
should have been included. I wouldn't agree with that argument here.
All right. Okay, so you're not comfortable with the legal notice, and so so you believe that the division has not provided the proper notice, much less just to protect us. You believe that the division has not provided proper notice.
I mean, I could lean either way, but the conservative approach is most definitely that the all should be included.
Ms. Bennett?
Mr. Examiner, I understand the division's concerns. I would also note, however, that this is a more of a pro forma approval by the division. The State Land Office has the final say about whether this unit will be approved. And so if the State Land Office has any concerns at all about notice or voluntary joinder in the unit, the State Land Office will be able to remedy that. These are state lands. The State Land Office is in favor of this application being approved, and it is a purely voluntary application. Parties cannot be forced. This is not forcing anyone into the unit. It's not pulling anyone into the unit. It's completely voluntary. So if, again, if the State Land Office has any concerns, the State Land Office will be the final arbiter of whether this unit gets approved.
So, Ms. Bennett, to help me understand how the state land is involved in this, so the state owns all the mineral interests here?
Yes, it does.
So then, but we had we did have objections from other entities. How could we, if this is just state lands, then how did we have objection? Okay, so you understand the question?
Yes, I do. Yes, so it is, I'd say it's unusual to have objections to the approval of a voluntary exploratory unit. And in fact, there have been other cases where the division's jurisdiction over these types of cases has been, I don't want to say questioned, but has been discussed. And so it is unusual, in my opinion, for there to be objections to voluntary units because they are purely voluntary. So if BTA did not want to be part of this unit, it didn't have to be, same with XTO, but that's still, the division does have an ability for folks to object. So that is what occurred.
I see it. I see Adams. Yeah. Mr. Rankin, I see your hand up.
Mr. Examiner, good morning. I thought I might just pipe in. I think there's a reason that the division does not have regulations addressing notice for voluntary units.
Okay.
And I think that Miss Bennett has addressed that, but I just wanted to, pipe in to make that point if it's helpful.
And you said that the division does not have notice requirements for voluntary agreement?
Correct, nor do they have regulations that govern the approval or require approval for voluntary agreements. It's part of the, well, I'll let Ms. Bennett address that, but it's not something that is, it's usually a requirement as part of the unit agreement itself, and not something that's required under the regulations.
I see.
That is correct.
Is there a rule number that I can look at?
No, there's no rule number,
there's no
period.
rule.
And the the only way this even comes before the division is because in the State Land Office's form of unit agreement, it requires OCD approval, but there is no OCD regulation. There's no OCD regulation that governs approval of unit agreements. And the State Land Office form does cite to the Oil and Gas Act generally, but does not provide any specific citation to the division's specific jurisdiction over these unit agreements.
So why did this matter come to the hearing bureau and not just get approved administratively?
I don't believe there's an administrative process for this. I've never seen one approved administratively.
Oh. Mr. McClure?
Mr. Hearing Examiner, it is correct that we do not have an administrative process for this.
Okay.
I don't know what else did you want me to weigh in on anything else or?
After hearing from Mr. Rankin and Ms. Bennett about, the voluntariness of the agreement and the fact that it involves just state lands and the State Land Office is the final arbiter of the approval and can also find fault with notice, I guess, if it wants to. How do you feel about it now? Does it change anything?
To be honest, my opinion isn't really changed because it's still our director that is signing whatever order comes out of this case. So I'm not sure as I would weigh. I apologize, Mr. Hearing Examiner.
There is an order that comes out of the division for this?
That is correct. There'll be an order that's issued. Now, within that order, it doesn't outright approve the unit. It recommends approval of the unit is what it does.
I see. Okay, I understand. Okay. Based on Ms. Bennett's argument, though, I feel like it makes me feel better. I'd rather see the word all. However, there isn't anything else there. I think if you read 4-6, I think the default assumption would be that it includes the entire section of 4-6. I know I might be leaving myself open to challenge in the future, but I believe that based on the facts in this case and not setting any kind of a precedent, that I could see that the notice was at minimum satisfactory in this case. So, Mr. McClure, do you have any questions for the witnesses in this case, or can we take this case under advisement?
Mr. Hearing Examiner, I do not have any questions for any witnesses, and I think we can take the case under advisement.
Okay, then we're off the record and we'll take this case under advisement. Thank you.
Thank you very much. I appreciate the thoughtful approach.
Ms. Vance, should I come back to you or go on to the next case before coming back to you?
I think I pretty much have the answers. Yes.
Well, when you say pretty much, that makes me nervous.
I'm just waiting on one piece of information, but I do have an answer to your initial question.
Let's wait till you have all your pieces, all your ducks in a row. I'm going to call the second RAS oil and gas case, which it seemed like I had called before. This is case 25081. Entries of appearance, please.
Good morning, Mr. Examiner. Dina Bennett on behalf of RAS Oil and Gas LLC.
Thank you. Are there any other parties?
Yes, there are.
Good morning, Mr. Examiner. Adam Rankin with Holland and Hart on behalf of Mewbourne Oil Company.
Good morning.
I believe that's it, Mr. Examiner.
Thank you. We have two technical examiners with us this morning, Mr. Millian Gebremichael and Mr. Phil Getz of the UIC group. They will have questions for the witnesses. Who are your witnesses this morning?
Thank you, Mr. Examiner. We have three witnesses, two of whom have previously testified. So we have Mr. Joshua Ticknor. He has not previously testified before the division. We have Mr. Thomas Tomastic, who has previously testified before the division, and Mr. Reed Davis, who's also previously testified before the division.
Okay, and Mr. Rankin, before I go on to swear in the witnesses and qualify one of them as an expert, are you objecting to this case?
Mr. Examiner, we are not. We had previously filed an objection on behalf of Mewbourne Oil Company. Subsequent to that, the parties have been able to resolve their differences and came to an agreement. I believe Ms. Bennett will discuss that agreement as part of her presentation or just review it. And I think she can address those questions. But basically, yeah, the parties have come to an agreement resolving Mewburn's concerns with the proposed injection, allowing us to withdraw our objection. I will
Okay,
have a
so-
couple questions, however, Mr. Examiner, for each of the applicant's witnesses, but no objections.
Okay, and you're not introducing any evidence of your own?
Correct. No
Okay.
witnesses or testimony.
Okay, let's get your witnesses sworn in first, Ms. Bennett.
Thank you. So would you like to run through Mr. Ticknor's qualifications? He's not previously been qualified.
I can do that with him directly.
Yes.
Okay, so let's get all three witnesses on our screen. Can we not share the screen yet?
Sorry, it'll take me just.
That's fine. Okay, I see Mr. Tomastic. I see Mr. Davis. I don't see the third witness.
Can
you not see me?
Now I can.
Hello.
Hello. And I see Mr. Ticknor. Would you all three raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Mr. Davis? Okay, very good. Thank you. Okay, so Mr. Davis, you've been previously qualified as an expert before this division?
That is correct.
In what field?
Geophysics.
Geophysics. Let me write this down. Davis, geophysics. Okay. Mr. Tomastic, in what field?
Mr. Hearing Examiner, I've been qualified as an expert in groundwater, underground injection control, and geology.
Okay, perfect. Thank you, sir. And now we come to Mr. Ticknor. Would you state and spell your name for the record, please?
My name is Joshua Ticknor, Joshua Ticknor.
Okay. And what field do you seek to be an expert before this division?
Saltwater disposal well operations, petroleum engineering matters, and any permitting matters related to UIC.
Okay. What education do you have toward that field?
I'm a petroleum engineer. I graduated in 2008 from the University of Tulsa.
With what degree?
A petroleum engineering degree.
Okay. And
Bachelor's of Science.
Okay. And what work experience do you have since graduation toward this degree?
Since 2008, I've worked at various operating companies throughout the United States, Oklahoma, Texas, Wyoming. And then for the past 7 years, I've worked for ALL Consulting as an expert on their disposal well permitting and injection well operations.
Okay. I didn't catch who you work for now.
ALL Consulting.
ALL Consulting.
Yes,
okay.
sir.
Okay. And you said you had worked in various states. With what companies?
Primarily, I've been with Cimarex and Newfield.
Cimarex. And your title was Cimarex when you were with them?
It was a reservoir engineer.
Reservoir engineer. Okay. And with ALL Consulting, can you tell me a little bit about what you've been doing with them?
I'm a project engineer. I help out as much as I can. I'm a professional engineer, so I review work and generate work on my own related to the engineering of injection wells, facilities. We also do testing on wells, separate testing and matters of that sort.
Okay. All right. So if I was going to put some words to your field, would it be petroleum engineer?
That is my title.
Okay. So from here on in, you're an expert as a petroleum engineer before this division. So Ms. Bennett?
Thank you. This is a case that involves a request to plug back an existing injection well. So currently RAS is authorized to inject produced water that's produced during oil and gas operations into the Devonian, which is a deep disposal area. That has become uneconomic due to surface pressures. And so RAS has requested the ability to plug back the well to the Delaware Mountain Group, specifically to so that would be a shallower interval to allow RAS to continue to inject produced water into the Bell Canyon Formation, which is one of the formations in the Delaware Mountain Group. And so that's the nub of the request today, is authority to plug back the well to that shallower injection level and be authorized to inject into the Bell Canyon Formation.
And what exhibits have you filed?
So we have filed the exhibits of Joshua Ticknor. With his exhibits, it includes his resume, the application that I filed, and the application also includes a C-108, and the C-108 is all of the backup documentation for a saltwater disposal well or produced water well. Exhibit A3 is a revised wellbore design or wellbore drawing. It was revised due to the agreement reached with Mewbourne regarding injection interval and injection volumes. Originally, RAS was proposing 20,000 barrels per day and reached an agreement with Mewbourne to limit injection to a maximum injection rate of 8,000 barrels per day. And originally, RAS was proposing to have the lower boundary of the injection interval be at 6,930 feet. But in discussions with Mewbourne, they agreed to raise the lower boundary to 6,104 feet. So that's the revised wellbore drawing. Just in full transparency, we will need to revise the wellbore drawing again due to some issues with the formation caps. So I can go through that a little bit more if you have specific questions, or I can give more detail on that. And then exhibit A4 is a volumetrics analysis. That's an analysis showing how far out the plume of water is anticipated to go. Exhibit A5 is an updated 1/2 mile area of review map. That's under the regulations. Then exhibit B is the self-affirmed declaration of Tom Tomastic. What he included in his exhibits is the OCD Delaware Mountain Group risk area map. And we've identified on that map where the Yo State well is located to show that it's outside what's called the DMGRA risk area. The exhibit C is the self-affirmed declaration of Mr. Davis. He included in that exhibit, or in his exhibits, a geology and seismic statement, which provides additional information about geology and seismic that was to supplement what was included in the C-108. And then the final tab is my notice exhibits, which shows that notice was done on December 16th, 2024. And that there was an affidavit of publication that was published. Publication was done on December 19th, 2024. So notice was timely. With that, I would ask that the exhibits in case 25081 be admitted into the record.
Are there any objections? Not hearing any, including Mr. Rankin. We will admit these exhibits into evidence, and we will first turn to Mr. Gebremichael for questions. Which witness would you like to question?
First witness I would like to question is Mr. Hearing Examiner is Mr. Ticknor.
Okay. Mr. Ticknor?
Yes.
Go right ahead.
Thank you very much. This question is for you, Mr. Ticknor. May I direct your attention to Exhibit A2, page 3 of 143?
Page 3?
Page 3 of 143, yeah.
Okay, we have it on the screen.
Yes.
I see it.
Yes, sir. You mentioned that injection into the Devonian was economically unviable. Why was it considered unviable? What was the reservoir situation? I know you mentioned the pressure issue, but I want you to go more into detail. What was the reservoir filled up? What was the rate of the pressure?
I know that the surface injection pressure was nearing the maximum allowable of the Devonian. I cannot recall the maximum at this point, but I would defer to Nick Thompson, who's the owner of the well, who maybe knows that. As injection operations occurred at the well, a skin factor developed that has increased pressure of the injection pressure at the surface, meaning that they were not allowed, or they are not able to inject into the well at a high enough rate to be commercially viable.
just a follow-up on this one. Have you performed any economic analysis?
No, not me personally. That would be in the wheelhouse of Nick Thompson also, who is the owner of the well.
Okay. All right, I'll proceed to the next question.
Can you turn off your microphone? Thank you.
All right, I'll proceed to the next question, and then this question is for Mr. Tickner as well. If I may direct your attention to Exhibit A2, page 4 of 143. Okay. Ras Oil and Mewbourne reach an agreement to limit the injection interval to 5,540 feet to 6,104 feet to a maximum injection volume of 8,000 barrels per day. So what was the rationale behind it? For this
The rationale behind what?
For limiting the injection interval and then the injection rate.
Mewbourne had concerns that the rate would be high enough and that the depth would be large enough that it may interfere with their ongoing operations. We reached an agreement to reduce the injection interval into the Bell Canyon and reduce the injection volume to 8,000 barrels per day, which is a significant decrease in the original proposal.
Also, there is a limitation in the, you kind of limited the injection interval as well.
That's right.
Mr. Examiner, I may also be able to provide a little insight into that if it's appropriate now or at the end of the questions.
Let's do it at the end of the.
Okay.
Did he explain why?
I wouldn't mind for more elaboration on this one.
Ask the witness to explain.
Mr. Examiner, that's the elaboration. I'd be able to provide that as it was a discussion between myself and Mewbourne's counsel.
All right, go ahead.
Thank you. When Mewbourne objected to the application, myself and Mewbourne's counsel engaged in discussions. And as a result of those discussions, Mewbourne proposed a reduction in the volume to 5,000 barrels of water per day and proposed this lower boundary. So it wasn't a decision that Ras Oil evaluated per se. It was one that was proposed to Ras based on Mewbourne's concerns about its ongoing operations. And so when we received that proposal from Mewbourne, we evaluated it and we counter proposed with 8,000. And so that's how the 8,000 number came to be. But this 6104, Ras agreed to that based on that being the proposal from Mewbourne.
Okay, thank you. I'll proceed to the next question. This question is for Mr. Tomastik. May I direct your attention to Exhibit 3, Attachment 6, which is on page 51 of 143.
51, you said?
Yes.
Yep.
Yeah, right there. You mentioned that there is 4,690 feet of separation composed of multiple isolation zones between the base of the USDW, which is 850 feet, and the top part of the injection zone. Can you characterize the multiple isolation zones in terms of lithology and porosity to qualify them as a confining zones?
As you're aware, Million, directly above the Delaware Mountain Group, above the top of the Bell Canyon, is the evaporite sequences of the Castile and then the Salado Formation, which were composed predominantly of anhydrites, some salt beds, and some very low porosity carbonate rocks, which is very distinguishable even on gamma ray neutron logs that are run through the Castile and Salado formation, basically showing they're relatively impermeable for upward fluid migration. So there's thousands of feet of multiple confining zones above the Delaware Mountain Group.
Thank you, Mr. Tomastic. When you say low porosity, can you give me an estimation of the porosity values?
Anhydrite salt beds are going to be less than 2%, and most of your carbonate rocks in that area probably will be between 2 and 4% porosity.
Thank you, Mr. Tomasik. I'll proceed to the next question. And this question is directed to you as well, Mr. Tomasik. If I may direct your attention to Exhibit A3, page 32 of 143. It's okay. Yes.
Yep.
Yeah, as depicted in the proposed diagram, both the salt formation and the Capitan Reef, which are approximately 4,478 feet to the top, and then 5,300 feet at the base, were protected with single intermediate string during the drilling. As you may know, this could cause erosion and saltification of the formation and then affect the cementation process. How confident are you that the cement bond is sufficient and provides hydraulic isolation to the USDW?
On which string of casing, the intermediate or the production casing, or both?
No, the intermediate during the drilling process. So I'm talking about the top of the salt and then the Capitan Reef, which is around 4,478 at the top. And then
I was unaware that we were in the area of the actual Capitan Reef. I thought we were outside of the reef on this area, but the intermediate casing is set through.
You are in the middle of the reef, actually. You are in the reef.
So it is in the reef. Okay.
Yeah.
So the cement is cemented to the surface, both in the 9 5/8 and in the 7-inch production casing. So everything that we've looked at indicates that there's complete isolation and no communication with the evaporites or with the Capitan Reef.
So your interpretation of the CBL, was that based on the CBL to confirm that the cementation is good enough?
There is a CBL that for this on the 7-inch production casing that I have reviewed.
Yeah, from what we noted there was a lot of rings, and then it was very hard to see how much of the cementation it is, but you're certain that there is a good isolation to the USDW, right?
Yes. I mean, typically on any cement job, unless you're drilling through the evaporite sequences with a saturated brine, you will get some washouts that then may not get a good formation to pipe bond on your cement bond log. So hundreds of wells that I've looked at in New Mexico through the evaporite sequences typically have zones in there that may indicate poor bonding, but there is no evidence of cement channelization, meaning that you would have the ability for formation fluid to migrate through a cement channel, potentially into the underground sources of drinking water.
Thank you, Mr. Tomasic. I'll proceed to the next question. This question is for Mr. Ticknor. May I direct your attention to Exhibit A3, page 69 of 143? Yeah, yeah. If you want to rotate it somehow. Yeah. Yes. That's great. Yeah. Thank you for the cylinder of in place waste model to simulate the injected spread. That was a good model. What are your assumptions regarding the real reservoir geometry of the injection zone? Specifically, what are your volumetric arc degree and porosity that closely resembles to the real reservoir geometry?
Okay, for these calculations, I used a 4% porosity, which is very low conservative estimate for this formation for the Delaware Mountain Group. I used the perforated interval for the height of the formation and a volume of 8,000 barrels per day in this instance.
What about the volumetric arc? Do you go with 15 degrees, 60
Yes.
degrees, 300? Which one did you pick? Which is closely resembles to the reservoir geometry?
This is a sensitivity analysis since there is not great detail on the reservoir geometry. This is in general, has been generalized. So the red arc being a 15-degree arc is the narrowest and it has the largest extent. So it has been placed on a direct line to the nearest penetration within the DMG as an orientation measure.
So you took the most spread as the scenario. Okay.
Yes. The largest extent is what I would say.
Okay. No, thank you. All right. And then I'll proceed to the next question. And then this question is directed to you, Mr. Ticknor as well. If I may direct your attention to Exhibit A3, page 68 of 143.
Yes.
Yes, a little bit down. What is your assessment of the plugged wellbore integrity? I'm talking about the API 30-25-35-108, which is 2.29 miles to the west of the subject well.
During our area of review, it did not present itself as a problem well.
What was your assessment? The way it was plugged? How did you assess the integrity going back to the well files?
We look at the well files, we look at the bond log, we look at the placement of the plugs. And the records indicate it was sufficiently plugged.
Okay, thank you. I'll proceed to the next question. This question is for Mr. Davis. May I direct your attention to Exhibit C, page 82 of 143? Thank you. Good job. Sir Davis, you stated that due to the significant vertical distance between the proposed injection interval and the nearest identified fault, the probability of induced seismicity is minimal. What is the vertical distance to the identified fault?
If I could direct you to the seismic letter exhibit, I have an exact value in there. From what I recall, it was approximately 2,000 feet.
2,000 feet. Yeah, okay. Which is significant enough. I just needed the value. Thank you very much.
You're welcome.
You done? Mr. Getz, do you have questions?
Yes, I have 3 information requests.
Oh,
And
request, but do you have any questions for the witnesses?
No, I do not.
Okay, perfect. What are your, I know Mr. Geber Michael has requests for the witnesses as well.
Okay.
So what are yours? Let's hear yours first.
Okay, thank you. First item, and I'll put this in Ms. Bennett's wheelhouse. Page 32 of 143 of your exhibits, we have a proposed recompletion wellbore diagram. I would request that we provide an updated one that shows the restrictions that Mewborn has made. And with that, all the differences made in placement of bridge plugs and other plugs in the well. So wellbore diagram that's current. Second item, page 49 of 143, we have a water sample that was done for a water well in the area. I request that we make part of the record the complete laboratory analysis, including chain of custody, not just the page where the analytics are posted. Finally, the third item, I think is more to Mr. Tomastik's expertise. In reviewing this application, I went through the 7-inch casing cement bond log run March 19th, 2017. In reviewing it, I have concerns between the say roughly from 53-55 feet down to 86-40 feet. I am seeing a response which to me raises questions and concerns of how good a seal you have behind the casing and with the formation. I've gone through the cement history, which is provided. It does not give us much in the way of what type of cement was used, excuse me. And also, I mean, it gives a summary of returns of 7 barrels and 9 barrels. So we're showing something coming, but not very much compared to what was done to the 2 other casings. I would like for all consulting or the specialists involved to take a look at this log and provide me a reason why I should not request some sort of remedial action to squeeze and to separate and isolate the portion of the Delaware Mountain Group that needs to be isolated so that we don't have migration of fluid down the backside of this casing into the zone that Mewborn has requested be left out of the injection interval. So the task here is to give us some reason to do it, and if you cannot sufficiently do it, at least give us an idea. If we were to do a squeeze, where you would put it just to isolate the lower portion of the Delaware Mountain Group. The upper seal on the 7-inch looks very good. It won't be an issue there. But at this point, the response I'm seeing through this portion of the 7-inch casing is very questionable. So that's my request. 3 items.
Okay, thank you, Mr. Getz. Ms. Bennett, did you make a note of those?
I did.
Okay, which exhibits are you going to be amending? Just give me the numbers.
Well, I'll be amending Exhibit A3, which is the amended wellbore or the wellbore diagram.
Okay,
The water sample is part of Exhibit A2.
okay,
And then it looks like we'll probably be providing a new exhibit to address the concerns with the cementing from 53-55 to 86-40.
perfect. Mr. Getz, did that capture what you said?
Yes, sir.
Okay,
Thank you.
Mr. You're welcome. Mr. Geber Michael?
Thank you, Mr. Hearing Examiner. These are the few requests. Pending the approval of the case, the OCD would like to inform me that it will put forth the following conditions of approval. In response to the self-affirmed declaration of Mr. Tickner stated on item 18, page 4, and then item 32 on page 6. I'll proceed with the request. The permittee must conduct a successful step rate test before the injection commences. OCD may reduce the maximum surface injection pressure of the UIC permit if the results of the step rate test show that the permitted pressure calculated using a gradient of 0.22 psi per foot of depth at the top of perforations exceeds the formation parting pressure. If the SRT outcome demonstrates an injection rate greater than 8,000 barrels per day, which is the rate agreed upon with Mewbourne, then the 8,000 barrels per day will be the injection rate. However, if the step rate test outcome demonstrates an injection rate lower than 8,000 barrels per day, then the lower injection rate resulted from step rate test will be used. And the step rate test shall be conducted for the Bell Canyon and Cherry Canyon formations separately. The least fracture gradient out of the two tested will be used to calculate the maximum surface injection pressure for the well. Have you captured it, or do you have any questions on this one?
So a successful step rate test, OCD could reduce the maximum allowable pressure based on the step rate test. And OCD could limit the maximum barrels per day based on the outcome of the step rate test.
Yes.
And one thing I would clarify is because of the raising of the lower boundary of the injection interval, RAS is not seeking to inject into the Cherry Canyon anymore. The Cherry Canyon tops are below the bottom of the bell or the injection interval. So do they need to do a step rate, or do they need to do those separately now? Or would it be sufficient to just run one on the Cherry Canyon and use that as the...
You mean Bell Canyon?
Sorry, Bell Canyon, yes.
Yeah. If you're limiting your injection to Bell Canyon, a test Bell Canyon would be suffice enough.
Yes, it's my understanding that by raising the injection interval lower boundary, that eliminated the Cherry Canyon from the injection interval.
Sure. All right. We were not aware of that one, but yeah.
Thank you.
The next one is if the cement squeeze operation is performed to bring the cement bond to the standard, then CBL must be submitted before the injection commences.
I understand that.
Okay.
I also understand from Mr. Tomastic that he might have a bit more information on the viability or the integrity of the casing that Mr. Getz was discussing that also relates to your
Yes.
condition. And so if in a moment after you're finished with the conditions of approval, if he could have just a minute to provide some follow-up information, I'd really appreciate that. Thank you.
Okay, I'll proceed with more requests. In 2 years after the commencement of injection, and then every 5 years thereafter, the RAS oil shall obtain static bottom hole pressure. And then it could be real or calculated. A Hall's plot, HALL, yeah, plot. An injection survey coupled with temperature and noise log.
I'm sorry, coupled with temperature and...
Temperature and noise log.
Oh, noise.
Or sonic log.
Mm-hmm.
Have you captured those?
I did. So 2 years and then every 5 years after.
Yeah, the first one's gonna be 2 years and then every 5 years after.
A static bottom hole log or bottom hole pressure using a Hall's plot and then injection survey coupled with temperature and noise.
Yes, ma'am.
Okay.
And then the next one is every 5 years. One is gonna be monitoring any production wells identified as potentially impacted by the disposal operation, if there are any. And then a follow-up test and mechanical integrity test. That's gonna be every 5 years.
What was the test before the MIT test?
Follow-off test.
Oh, follow off. Okay. Thank you.
Optional requirements available for inclusion in the UIC permit or requested based on the results. OCD will request a formation water sampling before commencement of injection. Next one is increased monitoring of production wells to include downhole pressure measurements.
May I ask a question about that one?
Yes.
Is that when you say monitoring of production wells? So I don't know that RAS operates any wells. So what sort of,
If there are any.
okay, if any?
Yeah.
Okay, thank you.
And then any additional tests that you perform, whether it's gonna be a defeat, that's another word for mini frac or tracer survey. All those reports, they must be filed to OCD within 60 days after the end date of the reporting period. That's all.
Thank you.
Thank you.
May I?
Mr. Rankin, did you have any questions?
Mr. Jammer, thank you. Yes, just a few for each witness. Thank you.
Okay, go ahead.
Mr. Ticknor, good day.
Yes.
Just, do you know how far the closest Delaware Mountain Group active disposal is located from this proposed location?
Yes, it is on page, I believe it's on page 68 of 143.
I stopped sharing, but I'll start sharing again in just a moment.
The closest active producing DMG well is 12.5 miles to the southwest.
Southwest, okay. Then you didn't identify any closer?
No, sir.
Okay. Do you know what rates those wells are accepting or able to accept for injection?
The closest saltwater disposal well
Yeah.
is that's actually I'm sorry, let me repeat or rephrase what I was telling you. The closest active producer in the DMG is 12.5 miles southwest. The closest active saltwater disposal well is 9.9 miles northwest.
Okay.
But I do not know the rate of that well off the top of my head. I would have to look into it.
Okay. Okay. No other questions for you, Mr. Ticknor.
Okay.
Mr. Tomastik, I just have a couple questions. You were addressing Mr. Geber-Michael's questions about the criteria or the characterization for barriers. And I think you addressed his questions about upward confining layers. And I just wanted to ask you what criteria, how did you characterize the presence of the lower confining intervals here?
Looking at the open hole geophysical log, there is multiple lower confining layers, both in the Cherry Canyon formation and the Brushy Canyon formation. Basically, there are low porosity, high resistivity zones. And we actually, I think, included that in the seismic letter exhibit, where we had done analysis of the lower zone.
And as for the upper zone, so you're looking at what criteria were you using to determine the lack of conductivity, similar to what you'd stated for the upper confining zones?
Correct.
Yeah, okay. And then as to potential frac gradient here, have you identified any offsetting wells that have conducted a step rate test to determine what the frac gradient might be in this interval?
I think Mr. Davis had looked at that, and it was quite a distance away. But you could ask him.
Okay. I think that's all I have for you, Mr. Tomestic. I'll ask this second question for Mr. Davis. Mr. Davis, how are you today?
Doing well. How are you?
I'm good. Mr. Davis, my question for you is, have you looked at any offsetting data for step rate tests that have been conducted for this interval?
Yes, the nearest offset SRT we were able to identify was approximately 20 miles away, and it indicated a fracture gradient of 0.36 psi per foot in the DMG.
Okay. And you hadn't identified anything closer based on your review?
That is correct.
Okay. Nothing further, Mr. Examiner. I appreciate the opportunity.
Thank you. Ms. Bennett, do you have a complete list of what the division wants in addition to what you've already filed?
I do. Thank you very much. I understand Mr. Geber-Michael's information was more conditions to the permit rather than information requested. I would ask if Mr. Tomastic could briefly respond to Mr. Getz's question about the integrity of the cement in below the Bell Canyon.
And then depending on where we are with redirect and this and that, we're going to break for lunch soon.
That's fine. I think we're almost finished.
Go ahead.
Okay. Mr. Tomastic, I understand that you heard Mr. Getz's questions and Mr. Getz's request for Raz to evaluate the integrity of the cement below the proposed injection interval. Do you recall that?
Yes.
And did you have something additional that you wanted to say in response to that condition?
Yes. First of all, prior to doing any perforating and squeezing, which at that point does jeopardize the integrity of your production casing, I would propose, after tubing and pack, the well is plugged back, tubing and packer has been withdrawn from the well, that we perform a new cement bond log, either a radial cement bond log or potentially a segmented bond log, both at surface pressure and also under pressure, potentially of 1500 PSI, as some of those areas that don't look like good cement bond could possibly be microannulus, which microannulus will not allow fluid movement through it. So we would propose, prior to doing any perforating and squeezing, to ensure that we do have either a microannulus or uncemented pipe to confirm one way or another before you would do any perforating and squeezing and jeopardizing the integrity of the 7-inch production casing.
Thank you for that. And of course, Raz is committed to coordinating with the division. And so if Mr. Getz has any concerns with that, or Mr. Geber-Michael, we're happy to follow up further through email or other communications to ensure that the division is completely satisfied. Yes, sorry, Mr. Geber-Michael.
Mr. Tomastic, okay, can you do the same procedure also for the intermediate casing? Because on our CBL, all we see is rings. And then if you could perform the same imaging for the one that
You're talking trying to be able to see through the 7-inch and in the backside of the 9 5/8. I don't know if that's possible. It's something we can check with some of the cement bond logging service providers. Typically in the past, I have been told that that's pretty difficult normally.
Yeah. Okay. All right. Thank you.
Mr. Getz, are we done for today?
Well, this is a dangerous situation, having Mr. Rankin and Mr. Tomastik all together in the same place for a different matter. To that end, I would support very much their approach to run a new CBL. Let's see what it looks like with a better tool, a radial. And let's get a decision based upon that. It may be that again, the information provided when this was filed, we have a variety of cements, different weights. It may be reflective of even a lighter cement. So let's do this. Let's go with their proposal. And at that time, we'll make a judgment call.
All right, so Mr. Getz and Mr. Geber-Michael, do you want to come back to continue the hearing on another day after they've submitted their additional information, or once they submit the information, you want to take the case under advisement? How do you want to proceed? Mr. Getz.
I would go with B. Go
B.
ahead and.
Okay, I understand. B is fine. Mr. Geber-Michael, you're in agreement? Okay. So then, Ms. Bennett, how long would you like to keep the record open to receive the additional information?
I'll need to coordinate with the witnesses to understand their availability to get this information together. So could we, for another case I had, another SWD case I had, you were kind enough to leave the record open essentially indefinitely. And then when I filed the revised exhibits, I alerted Mr. Geber-Michael that I had filed them. So if that's a possibility, that would probably be the easiest.
That's fine. That's what we'll do in this case. So, Ms. Bennett, what I'd like you to do is when you do file the amended exhibit packet with a cover letter to include, all the things you're doing, please send it to me and to Mr. Getz and Mr. Geber-Michael, so 3 of us, and upload it to the system as you normally would. At that time, the case will be taken under advisement.
Thank you, I will.
All right, we're off the record in this case. Now, I know that we have some cases to come back to after lunch. We have Ms. Vance, we have one case, right? Just one case. Ms. Hardy, what are we coming back for you for?
I am here for Mr. Swazo's 3 Riley
Okay,
cases.
the Riley cases. Okay,
Yes.
perfect. And I think Mr. McClure has said that he has had a chance to review the information. So after lunch, we'll pick up your cases, Mr. Swazo and Ms. Hardy. So we don't have to take a long break. I know that you may not want to go and come back, but the technical examiner and I need half an hour minimum to break. So do you prefer half an hour break?
Yes.
You would. Ms. Vance, you're okay with that? Half hour. Mr. McClure, you okay with half an hour?
That's fine, Mr. Hearing Examiner.
Okay, very good. Okay, we're off the record until, let's see, it's 12:03. At 12:33, we'll come back on the record. Thank you.
Mr. Examiner.
Yes.
Yeah, my name is Warren Anderson. I was in a case 25-16.